But in one bail application, regular bail application, your lordship has engaged one amicus query.
Hmm. Ah, yes. You have it in the afternoon. We realize the typing mistake.
Yeah.
Today too. Yes.
Well, I have to mention item number 28, my lord.
Hmm.
In this case, my lord, 3CR is received, but not tracked with the record, my lord. That may be tracked, my lord.
It has been submitted by the learned counsel for the petitioner that although the TCR has been received, it is not tagged with the
Item 28.
court record. Stop. Place this matter again on. Have it on the 6th?
6th. And my
6th of March.
Additional affidavit filed today in this case, my lord. That
Ah.
may be also in record.
Anyway, when it is coming up on 6th, what can we do it calling for the record today? It is anyway going back to the, is it not? Yes, sir.
Lordship, back to mention item 45. This is
45.
May I say that the matter may kindly be taken at 2 p.m. Many days it has been listed, but it could not be reached.
We'll try. একটু ডাক দিতে হোক, হ্যাঁ, যদি হিয়ারিং আরম্ভ হয় ফার্স্ট হ্যাঁ, yes.
That's why I beg to mention a criminal appeal. It was last posted on 5th of December last year, Lordship.
When do you want it?
On to Lordship, 2nd of
But
March.
there's a senior bench, you're supposed to mention it there. When there's a senior bench, I cannot be allowing mentions. The other case I have allowed because it was my order. Code 14. Yes,
Lordship, I beg to mention for listing in IA, Lordship. IA is for correction of order, Lordship.
my order.
Yes, Lordship. Today, to be listed today, Lordship.
Okay, my order.
May I please, Your Lordship, I would like to mention item number 18 to 23, Lordship.
18 to 23.
Transfer petition matter.
Yes.
Mr. Jet Alam's elder brother expired, Your Lordship, on 25th, Your Lordship. Kindly matter be fixed on 7th of March, Your Lordship. And Your Lordship, the report was called from the concerned police station.
We'll see on the, when do you want it?
7th of March, Your Lordship.
7th of March.
Saturday, Your Lordship.
7th of March, we are not there, and 7th of March, we cannot ask someone else to take up the matter. You can have it on the 9th, or we do not know.
The report is not receivable.
You have your report by then? 9th?
I think
9th?
9th.
9th of March, huh?
Better.
18 to 23. APP shall endeavor to have the report as directed by the earlier order. Yes,
Maybe the Lordship
Huh?
of item 31, my lord.
31, yes.
Lordship, the CD has not been received till now.
The CD is awaited. List the matter again on, you are on interim.
Lordship, there is an interim.
We will have it on the 20th of March, 20,
Lordship.
20 March. An interim order.
in this case, also charge sheet submitted.
Charge sheet is submitted.
Lordship submitted.
If the charge sheet is submitted, then we can make the interim absolute.
Lordship.
And as and when you receive a summon, you can go and appear in the lower court.
Lordship, then let the matter.
Let the matter reach. We'll do so. Yes,
Please, Your Lordship, taking consent from the other side, I beg to mention item number 46, Lordship. Kindly pass over the meter for the day.
Lordship, I am for respondent number 2.
any stay operating?
Yes. Yes.
When do you want it? When do you want it?
Sir, 3rd week of March.
Okay. At the request of the learned counsel for the petitioner, which is not objected to by the learned counsel for the respondent, list this matter again on 23rd of March. No, it's on a hearing date, 24th of March. Interim order continues.
Master, please.
With the consent of the petitioner, I beg to mention item 16, my lord. 16 is a part-head matter, my lord. There actually the court has asked for the record, and record is actually necessary, my lord. Unfortunately, when a record, I missed.
Eh?
Record has been received, my lord, but unfortunately I could not bring. To
You forgot it.
Sorry, my lord.
You forgot it.
Yes, my lord.
My lord, I think your lordship is maybe recollect that
NOC issue. my lord.
NOC issue is over from my lordship's side.
The
That one day,
1 day overage.
overage 1 day. Some more study is required, but I got a judgment of Chhattisgarh
Hmm.
where the date and the particular date which has been fixed by the thing. Over there, both are kind of exclusive.
Okay.
So that helps me, but I think what I'm feeling like, if it is there in already in one high court, there could be something in a Supreme Court. But I think, as your lordship is aware, because of this month, I could not, because of this month only, I could not study much.
I understand. Now, if we have, when do you want to have it then? Tell us.
Any, my lord, next week we can have.
When do you want to have it?
Or as per the convenience. Yes, sir.
Authorized করে দিও। After 12. Let it be 11 or 12.
Hmm?
11 or 16,
13,
madam.
13.
11 or 16.
No, 16. Either 17 or 18.
Oh,
11 even. 11 no money.
11 or 11.
Let it be on
11.
11th of March.
12. 12.
12,
12.
12, 12,
13.
13.
13.
Either 13th or 11th.
13th of March. At the request of the learned counsel for the parties. List again on 13th of March. But if it is not done on the 13th, we'll have to release it. Thereafter, we are not here
13
for some time.
No, no, let it.
So either it is on the 13th, you are prepared, or we release it, take your chance.
Let it be.
Let it keep as part.
We are
Part.
keeping it till 13th.
But
Thereafter, we'll.
That gives it something, my lord, that you have to study and have to be prepared.
Yes, that is what.
Declare.
Yes,
Worship, I beg to mention item number 33, Worship.
33.
Worship, diary is not available, Worship.
Huh?
Diary is not available.
CD is awaited. List again on 25th of March. Interim order continues. No interim.
Worship, there is entry. Worship, it will 27, 28, Worship.
27th or 28th.
28.
Huh? 28th you have to come alone. 27th we can try.
Worship, 27.
27? 27. March.
Chief, I am mentioning item number 43, kindly adjourn this matter for PPT.
Behalf of
43.
item 43. At the request of the learned counsel for the petitioner, list this matter again on when do you want it?
Next.
Next week. Next week is heavy. You take it on 10th of March? Yes, sir.
Item number 25 on behalf of R. Devi CDC.
Ah,
That's it. I have taken consent. That's it. She has got some brother's medical emergency. She is at Kolkata. That's it. Maybe taken up after 3 weeks. That's it.
ah,
Because of serious emergency.
Well, lordship,
ah.
she called me up and she said that she will be coming here next week. So taking time for 3 weeks is too much.
Then what's it? Then 2 weeks because of her brother's kidney transplant is going on.
So she called me just few minutes
Then
back.
it's okay.
They told me they will be back by Saturday.
List this matter again on the 10th of March at the request of the counsel for the parties. 10th of March.
Yeah, please, your lordship, I would like to mention item 38 of the daily list.
Hmm.
LCR was called for but not yet received. Let the matter be adjourned.
The matter is of 2018. It has been submitted that the TCR is yet to be received. Establish this matter again on 24th of March. Awaiting the TCR. Issue reminder. 24th.
May it please your lordship, I beg to mention item number 35.
35.
Your lordship, with the, as per the instruction of my client, your lordship, I pray for leave of withdrawal of the bail petition, anticipatory bail petition.
Learned counsel for the petitioner has submitted that He is under instructions not to press the present anticipatory bail petition, and therefore the same requires to be withdrawn. Full stop. Allowed. Full stop. Anticipatory bail petition closed on withdrawal.
That victim necessary item number 48 of the supply list method.
Hmm.
LCR not received method. So whether next week any date might not be possible.
Will we have it next week, sir? Oh, TCR, hai na?
This year.
TCR call for is yet awaited. List the matter again on the 10th of March.
10th. Value.
Yes, sir.
Things will go notice.
Issue notice to respondent number 2. Call for CD. List again on. Yes. From where is it? Golaghat.
10th of March.
Huh?
10th of March.
His hometown, he will know better, man.
Yes. When? 10th of March?
I'm different.
My pleasure, Lordship.
Hmm.
Going to the BNSF application. The prospects, to my limited knowledge, may in this case will not affect, I think, Lordship. Lordship, can you see the page 12 of the FIR, Lordship? So section 14 and 15 has been added in this. Yes, Lordship. I think section 14 and 15 on the prospect will not affect in this case, Lordship. At best, Lordship, to my limited knowledge, section 67B of the ITA will be affected, Lordship. When the incident occurred, Lordship, the petitioner himself was a minor.
Huh?
When the incident was occurred, Lordship, the petitioner himself was a minor, Lordship. Now,
How do we know?
Lordship,
How do we know? Where do
by
you
the
push it?
section 14 and 15 of the POCSO Act, Lordship.
22, 23. 3 years, 3 years ago.
Now,
Ah,
20 years.
yes.
Yes.
Yeah.
Lordship, page 16,
Huh?
page 17, Lordship,
Huh?
para 8, 9 and 10, Lordship. The trial court observation, Lordship.
Yes, what does it say?
The FIR lodged by the informant discloses that the informant's daughter was in a love relation with the accused from 2020 to 23,
Now he is 20 years.
20 years.
In 23, he was
He was 17.
17 years.
17.
So in fact, his 18th birthday is a happy birthday. That saves him. Huh? What is your date of birth? Where have you stated your date of birth?
Annex the FIR, his identity card, Lordship, he is a student, Lordship. BS second semester student. Page number 15, Lordship.
Why don't you give us the class 10 matriculation certificate for the date of?
No, your Lordship, kindly see page 15, Lordship. Page 15.
You know the
Lordship, date
difficulty
of
when the
birth,
court asks for a particular thing
Lordship.
and you try to take the court to some other thing.
I'm sorry, Lordship.
All interest is
I'm
lost.
sorry, Lordship.
2006, so 2014, 24, 18, yes. Have your instructions when? If he was a minor at that point of time, POCSO will not apply. If POCSO does not apply, then some old photographs, now he's saying that he wants to release. But that will be of a minor because the girl was a minor at that point of time.
Behind the first month, so only the 6th of March.
6th of March. Right now, we are not issuing notice to the respondent number 2 because if she's not a minor now,
Take the instruction.
we don't need it, huh? List again on the 6th of March for the learned APP to have there. I have instructions on the age of the petitioner at the time of occurrence of the incident.
That is not the case, may be called for, Lordship.
Huh? Learned APP may also have his case diary.
Obliged, Lordship.
Hmm.
May it please your lordship.
Ah.
Page 9 is the FIR, my lord. Lordship
Ah.
earlier dealt with the FIR, my lord. It granted interim protection to the owner of the truck and owner of the beetle nuts, my lord, and asked them to appear, my lord. Now here is the driver, my lord. He is in jail, my lord. Arrested on, my lord.
When are those two, the other two cases fixed?
Those are big, man, because interim was there, my lord. just fixed manner down.
On?
কোন তারিখে আছে? 23rd or নাকি?
23rd of, I think.
23rd or নাকি?
The entire must be answered to them.
What about this person?
He is the driver, my lord.
Behind the bars.
So we'll have the same CD, different cases.
Same case plus,
You should have told us on that day that there is another person coming up, keep it short. We would have kept
No,
it
my lord,
short.
Actually, if we get a good result, then only it cases come.
Oh,
We were frank, man. There is.
sorted, I would like to.
11th of March. Call for the CD. Call for the CD 11th of March.
May it please your
Ah,
lordship. Lordship, This regular bail 19 days lordship.
Ah.
Yeah, the FIR lordship will find on page 14, but in page 15 lordship, kindly peruse the middle part lordship.
Ah.
Regarding recovery from this present petitioner lordship, that is said lordship, 13 numbers of strip containing 312 number of tablet of hydrochloride and acetaminophen. Lordship, acetaminophen lordship, its alternative name is lordship paracetamol lordship. And if it is lordship hydrochloride lordship without lordship tramadol, probably it will not come under lordship NDPS Act lordship. So far my limited knowledge.
So he is not only dealing in NDPS, he's also tricking people to believe that non-NDPS is NDPS.
But
Ah.
lordship, this petitioner is an
He's
addicted
selling
person.
things which are non-NDPS,
Yes, Lord.
telling people that this is also NDPS, you'll have the kick, take it.
But he was recovery
Ah.
from him only that.
Not only a drug trafficker, also a cheat. He should be.
But lordship, his lordship, yeah, the recovery from.
We'll call for the CD.
Yes, lordship.
Call for the CD list again on 13.
Oblige. 13, can it be on 14? Not 14.
Huh? On 14. Yes.
Oh, 14 is Saturday, lordship. Then 16 lordship. 16 lordship. Highly obliged.
16.
Yeah, please, your lordship.
Huh?
Hello, lordship will call for the case diary. And my lord, another prayer I have made, my lord, because my lord, I was soon arrested on 21st, my lord,
Ah.
of January. But my lord, I was asked to come in the police station on 19th. I arrived at my lord 8:30 PM at a police station.
On 19.
On 19th, my lord, yes, that I have mentioned in my para 4, my lord. I was kept in the lockup, my lord, and subsequently on my lord, 21st, my lord, I was soon arrested. For that reason, my lord,
21st of July.
January, my lord.
January.
FIR am not named in the FIR, my lord. Because of some suspicion, my lord, I was asked to come to the police station. I came to the police station, my lord. Then, my lord, after more than 36 hours, my lord, I have been arrested in the case, my lord. Whether, my lord, the GD entry and the, my lord, the CCTV footage of the, my lord, the police station.
Mr. Chaudhary Learned Counsel appearing for the Mr. B.M. Chaudhary Learned Counsel appearing for the petition has submitted that although the petitioner was taken into custody on the 19th, my
On
the 19th of January 2026, the arrest has been shown to be on the
21st, my lord.
21st of
Okay,
January
right.
2026. Full stop. Call for the case diary. The learned APPC also have instructions as to whether the allegations made by the petitioner are correct. Have your instructions? Huh?
Only, my lord, I have made it.
They may have this, they may have the CCTV and GD entries verified. Have a verification done of the CCTV, GD entry, everything. Nowadays, CCTVs are working, hopefully.
I was told that, my lord, it is working because his wife next day morning went there, my lord.
It was working.
As per, my lord, the wife of the, who has shown in the affidavit, my lord. I am obliged. Your
When,
16-3.
16-3.
It will be a wrong date.
Too late.
Can it be on 9th?
If the arrest is wrong, sir,
Yes, my lord.
Then 10th was taken.
Can it be 9th, my lord?
9th, yes, 9th. 9th.
I am obliged. Your lordship.
Then 6.
Please, Lord.
Yes.
Call for CD, Lord.
Huh?
Kindly call for CD and details later.
Call for the CD list again on 16.
Commercial earlier, please, Lord.
Huh?
Little bit earlier, 10th or 9th.
10th, 9 not possible. Loaded. Huh?
Matter of commercial quantity.
Commercial quantity, but.
Commercial quantity. 13.
Lord.
Obliged.
Bad figure lot.
Ah.
All the offences are, my lord, up to 7 years, my lord.
Huh.
My lord, as held by Honorable Apex Court in earlier, I will come, my lord.
Eh.
Similar matters are also pending. That compliance of, my lord, subsection 3 of section 35, now, my lord,
Huh.
it is mandatory. If, my lord, it has not been complied with, my lord, then, my lord, I am entitled to bail, your lordship.
Acha.
And in the case of V1, my lord, Honorable Apex Court held that, my lord, if the arrest is found to be illegal, my lord, in that case, when keeping me behind the bars for a second, my lord, is not permissible, my lord. My lord, FIR, my lord, kindly see.
These type of things we have dealt with earlier.
My lord, my
Eh?
brother, that was my own brother.
Ah.
My lord, I was working with my brother, who was, my lord, happens to be, my lord, a super distributor of a company, Radiant, who is informed before this honorable court. My lord, there is allegation against, my lord, business, my lord, correspondent, not against, my lord, super distributor. That after deactivation of wallet, just like, my lord, GPay and all.
How are you involved? We
I'm-
remember, we remember that story. No.
My lord,
That
I am not-
it was reactivated, then somehow they got it reactivated, then they were doing
Since I
transactions.
was working with my brother, my lord.
Ah.
I was arrested. I was in police custody for 6 days. Now I am in judicial custody. FIR per se, my lord, prima facie, it does not disclose any offense against me. I have not been named, and there is no accusation against me also, my lord. And all
Let us have the CD when?
that case is fixed on 19 too long, my lord. I am
19 March.
he's
We will ask for the CD again and again, then it keeps going round and round. That is
he
another
can
problem.
prepone that matter also. If 10th, it may be fixed, my lord. Otherwise, your lordship may grant me entry. my
Ah,
lord.
you can do it. If on the 10th you have the CD, he can make a mention. We'll have both the matters together. Is it not on 10th? Huh? We'll take this on 10th. Call for the CD list again on 10th. Huh? 10th of March.
It may be tagged, my lord, if
No.
no.
After this in the
If it is tagged, this goes to 19th.
I will mention, my lord.
Huh? 10th, if the CD is here, make a mention.
Mine. Will.
That the CD is already here. Hai na?
Deeply.
Yes.
Please, Your Honor. On a NDPS matter, kindly CD will be called for.
CD may be called for. Call for the CD 13th. 13th of March.
Obliged.
Here's your lordship.
Hmm.
483 bail application.
Huh?
CD may be called for your lordship.
Call for the CD list again on the 16th of March.
Lordship. Obliged.
Just a minute.
So the petitioner number 1, is one bail application is pending, Lordship.
Wait.
In concerned court, Lordship.
Ah,
I can give the number, Lordship, Miss Bail 33/26.
My lord, pass over the matter for time being, my lord.
for the time being. At the time being.
May I please?
Oh, yes.
PRS bail application.
Ah,
PRS bail
What did you
application, my
do?
lord. The petitioner before your lordship, he is a doctor by profession.
kindly have page 12.
Lordship. 12, my
1 to 12.
lordship.
Is it legible by any angle?
This is a
If
certificate.
it is not, how do we read it and why do you give it?
This is a certified copy. I have the original copy. It's the same, my lord.
Make an objection to the to trial court. What kind of a certified copy are you giving? Yes, sir.
But
This is something you had given to the court and the court take cognizance on this. Read 3 sentences from the top. Forget it, read 3 words from the top.
I have seen it, my lord. I have seen it.
Very difficult.
Why are the courts accepting this? Or is it WhatsApp copies?
No, my lord. This is the original. I have the certified copy. Original certified copy.
This is the print. The printout is bad or the
The printer maybe. This is
the trial court printer is bad or this is what comes to the court.
Yes, but
And in most of the pages, my lord, last few days I have seen. this.
Ah, This is what is happening, na? Nothing readable. Which code is it?
Otherwise, my lord, if lordship comes to the annexure 2, my lord, page 17.
CGM Kamrup Metro.
You are not.
Then Kamrup Metro.
How can we read copies before we give?
But the FIR,
Where is the affair? Huh?
it's on page 15, that is legible.
Why is it? Then this is okay.
This is okay, man.
Then how come this is? But then this has come from the police station.
This has come from police station.
This illegible copies have come from the police station.
That is the format of
See,
the FIR.
the 12 illegible, certified on 22/2026. 15 completely legible. Again certified on 22/2006. Same printer.
Then printer. But the font size of the.
So this page 12 has come like this to the court. You have to.
Yes.
Yes. What is the affair?
Lordship, if first comes to page 17, my lord, annexure 2. Lordship got it, my lord.
Just a minute. When a group of intoxicated men.
That's why I'm.
Yes.
Page 17, my lord. This is the FIR. I went to lodge this FIR on that intervening night, my lord. My FIR was the officer on duty. She refused to register the FIR. This is the FIR, my lord. Kindly have a look.
The main thing
Page
is that this
17.
man knows nothing. This man knows nothing. I'm sorry to say. What is stationary?
Lordship.
What does stationary mean? A vehicle is stationary.
Doctor, my lord, that is
What do you mean by stationary thing?
that is his language, my lord.
And what do you say about?
That was not in motion.
He has passed competitive exams to get into that.
He's a
To get to
doctor,
that
managing
degree.
Director of Cosmo Medical, my lord.
He had to pass certain examinations competing over everyone. And this is his English. He has studied in Assamese. And he
I'm
will go
sorry
inside
for
the
that.
police station and create a ruckus and he will no interview on this.
Lordship, kindly have a look, my lord.
What?
Page 17, my
Why
lord.
did he misbehave with the police?
Lordship, there is no misbehavior, and few people were there. He is a doctor, my lord.
So
Lord, kindly have a
someone
look.
goes to
Page
his clinic and creates a ruckus, will he let him have anticipatory bail?
accident took place, my lord. One accident took place. He went to inform the police station. That was refused, my lord. The English is bad, man.
No, English is otherwise. They ask him that we know what will happen in the police case. Then they say whether we want to go for a medical test or not is our.
Even this
If these
particular
people,
doctor,
if these people create a ruckus in the police station,
he is not the sole person, my lord.
led by.
That is led. But he was injured. Admittedly, he was injured. That is in page 15.
So he went for help to the police station. He went for help to the police station. He should have asked for help.
Their FIR was the concerned police official. They refused to register the FIR. Even only
It will be registered in the traffic branch, sir.
That was midnight, sir.
It will be registered in the traffic branch. Maybe in the morning.
And they went to the officer on duty at that point of time.
Yes, what do you say? This man creating a ruckus in the police station, should I allow an anticipatory bail? He will go back to the station and police station and say, look, now I got a bill. Batao ab. What we have seen in the movies.
I am apologizing, my lord, for that behavior, my lord, but kindly consider the FIR as well as page 17, my FIR.
But in the main FIR, the main FIR of paragraph 3, when I informed them.
Paragraph 3, my lord, comes to paragraph 3 of the page 15.
And this is by a lady. The police officer is a lady.
She was on duty at that point.
When I informed them that.
It's a lady attending the police station at 12 in the midnight. Educated doctor, 2-3 friends.
It was refused to register, my lord.
So go back in the morning, go to the SP.
Some altercation took place. I
Go,
didn't
go,
even-
go to the SP. Go to the best people you know. You will
He
not.
was, at that point of time, he was injured, my lord. And it is from page 15 only.
Earliest time, yes. When is the earliest date?
Kindly consider, my lord.
6th.
Educated man.
I understand.
Uneducated fellow going and screaming in the police station, we
But the main
understand.
point is, my lord,
He
that
will not
affair was
respect the law. He will not respect the law. He will not respect the officers.
definitely-
And then he will expect the law to come to his aid. Over and above that officer. Last
See,
man to do
doctor,
it.
my lord, doctor and managing director, my lord, one hospital, my lord. Kindly consider that part, my lord.
6th.
Till then, my lord, some protection.
No misbehavior in the, no misbehavior with the
Well,
law keeping agency. Now, if that lady had used a stick to control his anger, what would be
I
the
understand,
situation?
madam, but they were misbehaved at the earliest point of time. They were misbehaved as informed by the client.
We'll have that in the CD. Someone else is also looking into the case. She's not the person who had misbehaved or was misbehaved. Is not the IO. Someone else is the IO. We'll trust the other IO. He comes up with one statement that this lady started first. We'll have a case registered against the lady itself for misusing her part.
That is one part, my lord, but kindly
No,
consider, my lord.
No showing
is the
force.
responsible
No
person
showing
under me.
force. No showing force.
Deeply.
6th. Yes, can we have it earlier? Make it 5th. Make it 5th. 5th. We'll put
My
on
lord, there are some problems.
6th.
Lordship, this is an anticipatory bill application that
Ah.
had page number 17 minutes,
17.
17 minutes.
Yes, what happened?
Yes, my lord. So, may I read the FIR? So, my lords, basically, may I read it, my lords?
Not necessary. Then what happened?
Then what
You were
happened actually,
carrying.
my lord, the reason I am anticipating arrest is because, my lords, from the vehicle, the police said that there were two persons were coming on a narco. There was a prior information on which they see some contraband items. However, my lords, today I am anticipating arrest because of page number 27, my lords.
Sorry?
Page number 27. So this is allegedly, my lords.
Just a minute. Just a minute. Page number 20.
So 17 is the FIR, my lords.
Uh,
So in that case, my lords, they said that there were two people who actually escaped, my lords. That was they did not come in the folds of the police. And they could not find anyone, my lords, who was driving the vehicle. So I stay in, my lords, in Borpeta district in Bhabanipur, and this was in Dimakuchi, somewhere in Dimakuchi, my lords. The reason today I'm anticipating arrest is because, my lords, of page number 27, my lords. So in page number 27, what had happened, my lords? I had actually lent some money, financial money to one of a person, my lords. So in that, my lords, there has been some security in the sense of, my lords, at least a paper should be made, because in any financial transaction there should be some give and take. My lord, that was back in 2023, and agreement was made back in 2023, my lords, of a sum of only, my lords, 1,50,000. My lords, so before this case, I did not know of this, that what for what reason the vehicle was used for or where the vehicle was used for. But the reason when I got to know the agreement that I made way 3 years back has actually now been indulged in an offense. So that may be a reason for me to get arrested, my lords.
Recovered from 62 point something kg of ganja. So case diary at least.
But allegedly,
case diary.
no, if he has won it in some lottery, that is what the agreement says. Won it in a lottery and he had given it for hire. Maybe he can appear and
That reflect on the case diary. After the case diary.
interim may be given, my lords. Anyways, we'll submit to whatever.
let him give the documents. Once the documents are there, if the IO is not satisfied, point it out to us.
Yes, but whether these document is provided to whether these document is provided to IO or not.
If he doesn't provide these documents to the IO, this document was found in the car.
No, my lords. It was with me because not in the car, my lords. Because I went in an agreement back in 2023, my lords. Well, in any matter, my lords, when this matters comes up for final hearing, my lords, that will be always subjected to the investigation done by the IO, my lords. So today, my lords, if on just basis of this agreement, I have to be arrested, even a 1 day of custody would be too harsh on me. Just on the basis of this agreement, my lords.
Yes, but then if he can produce this document before you, he gave it to an Deepak Kolita.
Yes.
He will also come into the fold. You can trace the vehicle. It will be easier for your investigation if he appears and gives you all the document. Once you arrest him, you will get nothing.
Agreement was made on
2023 to one Deepak Kolita. So the Deepak Kolita now comes into fold. Is it not?
Yes.
How that vehicle reached that particular point of time is what Deepak Kolita will have to explain now. Now, once Deepak Kolita comes before this court, because he took it on hire. Huh?
Whether it was.
Well, the owner is not me.
Then why did you give it?
Owner is first Somiran Taluk.
You won it.
No, my lords.
Just a minute. You took it on hire.
No, my lords. So basically what happened.
You took it.
No, my lords. So the owner is my lords. My lords, may I read it, para number 3, my lords.
No. Yes.
Para number 3 of the agreement.
So you took the vehicle.
No, my lords. This was just for the agreement, for the purpose of agreement, my lords. Not.
You took the vehicle.
No, my lords. I was
Samiran
not in the
Talukdar
position
took
of
the vehicle.
Well, I was not in the position of the vehicle, my lords.
Where did you send it? To whom did you give?
No, my lords. I did not give. I was not in the position, my lords, because I am not the owner of the vehicle, my lords.
Kindly see, Samiran Talukdar has taken this vehicle from the second party, from Deepak Kolita.
But
This vehicle is found in.
this is only for the sake of agreement. Not, I have not taken.
Where was your vehicle?
Well, the vehicle was in the position of the Deepak Kolita only, because Deepak Kolita is also not the owner, my lords.
Where is it shown?
So, the agreement says so, my lords.
When? Earliest? Oh, we were thinking it the other way around. You had won it and given it to
Keep the
Deepak.
vehicle to first party as security of the above money.
Ah,
Everything is for.
it is with him. When?
10-3.
10-3. Call for the CD.
I'm so pleasant.
I'm being item 9.
My lord, I was told that there is a pending bail application. We have checked, the names are different. It may be some other co-accused. I have taken telephonic instruction. They said no bail application with regard to this particular accused is pending before any court, my lord. So
Yes,
that's the case they come, my lord, because the names are also admittedly the surname are different. I have also checked now.
One is, this is Lordship Ajit, and that one is Ajit. D. I'm not sure, Lordship, whether it is same or different.
Because
Call for the case diary.
Miscellaneous bail, Lordship, 33 of the.
Also call for the scan copy of.
Miscellaneous bail, 33 of the 26.
Here, listen to him. Also call for the
Miscellaneous
scan
bail,
copy of miscellaneous bail.
33 of the 26 before the district and session judge, Vishwanath.
if that be so, let him face the music, my lord. I am not here to defend somebody.
I know. And that is why when the time was sought for.
No. My lord, at least
We did
if
not
they,
take
if they take the lawyer for a ride, then they should also face
The
the
thing is,
consequence.
day or two before, we were also, it was also brought to our notice, the Supreme Court has given a format in some Zeba case as to what all has to be put into. Day before yesterday, we have passed an order that every case in the lower court, in the trial courts, in the court of first instance, everywhere there has been a bail petition. It has to be mentioned and it has to be put up before us.
Even
The orders have to be here. Every approach to the court has to be told to us. Let us hope it comes into. We just need to know.
Absolutely.
It will not affect the consideration of the bail.
Yes. But we cannot have two bail applications pending.
It is not about two bail applications, sir. It is more about यहाँ से नहीं तो वहां से हो जाएगा. This game has to stop. यहाँ से नहीं हुआ फिर वहां से होगा. That is another issue. यहाँ नहीं तो वहां has to stop. 16-3.
I'm deeply aware.
Matt, Lordship, this is an anticipated application, Lordship. Before going into the FIR, Lordship, may I submit the gist of the matter, Lordship? Lordship, I am the driver of a vehicle carrying, Lordship, Nestle products. I have started for Agartala, Lordship, and on 18th, I have started for Agartala. On 20th evening, Lordship, in the night hours, Lordship, I met with an accident in Koringmanj bypass, Lordship. Sribhumi, it is called now. Then I have ran away from the place because hue and cry has started to erupt there, Lordship. Immediately in the morning, 5:30, I have informed the complainant, Lordship, who used to look after the affairs of these vehicles, Lordship. And I have informed about the matter. He immediately rushed to the spots. But despite asking about my whereabouts and all these aspects, Lordship, he has started to threaten me to compensate the possible loss incurred by the vehicles or the goods, Lordship. Then, since then, Lordship, he has started to coerce me that, I mean, either you make a settlement with me or compensate, or else I will file a case, Lordship. So, after 15 days from the alleged occurrence of incident, Lordship, he has filed a case, Lordship. On 20th, the accident took place. On 21st morning, I have informed him. On 6th of December, he has filed a case, Lordship. So, this case is completely a fabricated case to just teach me a lesson, Lordship. And for not complying with his Lordship, not legitimate demands, Lordship. May I go to the vernacular parts of the FIR, Lordship?
Yes, Mr. Goswami. He was carrying legitimate goods. It met with an accident. He fled. Some of the goods are missing. Nestle products lying on the field or in the road. Some of it will go missing. I think we'll allow him to appear. Heard, Mr.
N.A. Machargoye.
The counsel for the petitioner also heard Mr. D.P. Goswami. The allegation in the FIR is that the petitioner had been driving a vehicle which had contained Nestle goods, and having met with an accident, he fled away, thereby leaving the goods unprotected. The allegation in the FIR is that a huge quantity of the good has gone missing.
Yes,
sir. In the facts and circumstances, this court is of the opinion that the appearance of the petitioner before the investigating authority to explain the circumstances will help the investigation of the matter. List the matter again on. We'll have it on 25th of March 2026. The petitioner shall appear before the investigating officer on or before the 13th of March. On or before 13th of March 2026. Full stop. In the event of his arrest, he shall be released on bail on furnishing a bond of rupees 10,000 with one surety of the like amount to the satisfaction of the arresting authority.
Grateful, Lordship.
Yes, sir.
For today, Lordship, I will pray for calling the TCR. It's after search. I will not pray for interim, because one criminal petition is already pending. That is listed today before Honorable Justice Jahan.
Okay. Call for the trial court records list again on when will we have it?
9.
30?
9. Because
10th?
No, pending before PRC case number 32.
That they will be.
Pending
Call for when we say call for the
first
TCR.
class.
But if it is charge sheeted, why the AB?
What has happened?
You were not arrested during the investigation.
He is not arrested. What has happened? The allegation is manipulation of pipeline of Oil India. Now 15.2 and 15.4 of the petroleum products has been alleged. Now 15.4, only 15.4 contains a bar for 438. That I'll explain because even if everything is taken to be true, 15.4 is not attractive.
Okay.
Therefore, I am not.
We'll have it on the 8th or 10th.
10th.
Then
Therefore, I am not seeking any interim bill today.
Okay.
Please, Your Lordship.
Notice to the respondent number 2.
Although POCSO is there, but one person was arrested and the forwarding report clearly shows my innocence. For a moment, my lord, kindly have a look the forwarding report, which is at page number 19, 11 portion.
Page number
19. Ground of arrest of that person, my lord. One Bobidul Haq was arrested on the basis of the statement of the victim, my lord. What the victim said, my lord, that was reflected here in my lord. At paragraph 2, my lord, ground of arrest, 19 page number. During her statement and interrogation, the victim girl disclosed that she had been on the influence of some other person. My name was uttered, my lord, by the way.
No, I do not understand the story.
Paragraph, may I read, my lord? During her statement and interrogation, the victim girl disclosed that she had been sexually exploited by her boyfriend, namely Bobidul Majid, alias Injamul Haq. She further said that she was influenced and lured with the promise of a large amount of money to make allegation against the FIR name accused Monwar Hussain. I am Monwar Hussain, my lord. This indicates that the minor victim was misguided, induced, and used by the accused person and his accomplice for their wrongful gain, my lord. I am Monwar Hussain, my lord. My name was uttered by the victim girl because someone influenced her, this Bobidul Majid, my lord.
Where is your FIR? Where is the FIR regarding you?
FIR is at page number, my lord. 16 is the vernacular one, my lord. And the type copy is, my lord, at page 12. 16 is the vernacular one, if your lordship, my lord, please.
We are also having a tendency to read the vernacular in most of the cases now.
My lord.
One or two words missing, the entire tenor changes.
Yes, my lord. It is very good to read.
But we can trust you.
My lord.
We can trust you. Let us read.
The below 16, my lord, read the vernacular, my lord. If your lordship.
No, we'll go by the English version.
My lord. At page number 12, my lord.
Yes.
In the FIR allegation is against the petitioner.
And in the
Grounds for present forwarding as well as statement
forwarding of the other fellow.
Yes. He influenced and promised to raise a large amount of money against the petitioners. As per her statement, she further stated that
You are not yet arrested.
Not yet arrested. She was influenced and lured and the promise of a large amount of money to make allegations against the FIR name accused, Monwar Hussain.
We'll issue notice to the respondent number 2.
Yes.
And when can you have it? Without the presence of the respondent number 2, we cannot do it.
Yes.
But this seems to be just appears to be. Should we have an amicus before that?
But service is without the completion of the service.
Till that time, he'll be arrested and put behind.
Then some infractions if I was arrested, my lord. Interim may be given, my lord,
But
because
with the kind of thing that police has already put up in the ground of arrest, I don't think they are going to arrest him at this stage.
Yes. The harsh statement by missing materials against that. Yes.
Same. Just a minute. How do we know it is the same incident?
Case number is, my lord, page number 18, my lord. Article of case number 17/2026. Case number is there, my lord. 18 page.
I don't think we are under a threat of arrest as of now.
Police is.
How soon? How soon? Hatigam?
Police is otherwise visiting.
Fifth or sixth.
Huh?
Fifth or sixth.
This house statement is required in this case.
Huh?
House statement is required. Yes, it is very much required, my lord. House statement.
No, the statement would be available in the other part, huh? That Babidul Masjid.
Yes, Babidul Masjid.
Say the statement has already been taken. Fifth. Can we?
Otherwise,
Without issuing notice, can we? Just tell us that.
so far, my lord,
Eh?
document shows that my mind.
Incident is of 23-1. He has managed for nearly a month. Let him manage for 2 or 3 days more. 2 or 3 days more, let him manage. Without the notice on the respondent number 2, we cannot.
That is
Huh?
because of this.
We'll have to express our mind on the merit of the case. Can we do that in a bail petition or an anticipatory bail? Should we? No. Let him manage for 3 days more. Fifth, notice on the respondent number 2. Steps within today itself. Mr. Goswami, nature of the matter, kindly have it on priority. Huh? List again on the 5th along with CD.
15.
Yes.
My lord, briefly, my lord, the allegation is that, my lord, 10 numbers of cattle were recovered from a Bolero pickup. The cattle were recovered, vehicle detained. Petitioner happened to be the owner of the vehicle. My lord. That's my case. My lord. Let him appear, my lord. Case number 17 is the FIR. Last page. Last page 25 is the RC.
Who was driving the vehicle?
That person is not named in the FIR, my lord.
Have you named him?
No, yes, my
Go for
lord.
it.
My lord, I will kindly come to para number 7.
You have named him.
I have given the vehicle to one Talewale. The petitioner is not concerned with the day-to-day business of this vehicle.
7.
7. Talewale.
Heard Mr. So-and-so learned counsel appearing for the petitioner. The learned counsel for the petitioner submits that the vehicle involved is a commercial vehicle. Is it a commercial vehicle? Huh?
Commercial vehicle.
Commercial vehicle. From which some cattle had been seized. Stop. The driver had escaped. The learned counsel for the petitioner has submitted that the petitioner had given the vehicle on hire and therefore is not connected with the carrying of the seized cattle. This court is of the opinion that the appearance of the petitioner before the investigating officer would facilitate the investigation. Therefore, call for the case diary. List again on 25th of March. 25th of March. The petitioner shall appear before the investigating officer on or before the 13th of March to cooperate with the investigation. Bill to complete did your admission?
Highly obliged.
For admission, attend 17.
Wait to the lord. My lord, we have filed this application under erstwhile CRPC, assailing the Ejahar and the continuance of proceeding. So the page 14 is the Ejahar, if lordship permits, I may read that. Before that, I'd just like to indicate a proprietorship concern firm and two of its employees and the proprietor are before your lordships.
Who?
A proprietorship firm,
Ah.
the proprietor and two of its employees are before your lordships. May
Mhm,
I? Sir, most respectfully it is stated that as per the words of one Dilip Nath of Goya village, we got introduced with manager of an NGO and the manager had explained to us about availing loans from local banks for fish rearing, poultry and honeybee farming and being independent. As Dilip Nath was local, we trusted him, paid heed about the schemes and the loans. After much deliberations and meetings, the time for availing the loans had approached close. The NGO finalized the bank as UCO Bank, Telamara branch, and Union Bank, Tezpur branch. From both these banks, loan amounts to the tune of rupees 1,50,000, 1,40,000, and rupees 1,20,000 was shown sanctioned. But these loan amounts were not reflected in our passbooks. It means that we did not receive the loan amounts. All our loan amounts were credited to the personal account of Shivankar Das, the manager of the NGO, with an understanding with the manager of the bank. We did not know anything about this. All the loan seekers were made to sign documents outside the bank. As the documents were in English, we did not know what was written thereat. There was no signature by us in presence of the manager of the bank. After some days, when the repayment notice was issued to us by the banks, it was then when we realized about the cheats. We pray that the cheats who had cheated poor people like us by playing fraud be punished. The persons who had falsely promised to us are Dilip Nath, Shivankar Nath, Nanu Boru, Pink Sharma, Kaustubh Das, Gautam Paikya, and the bank officials, Sri Neelam Das, manager UCO Bank, Telamara branch, Sri Upasana Paikya, manager Union Bank, Tezpur branch. These persons have sucked up our blood. Sri Shivankar Das, who is the manager of the NGO by the name of Tripura Organic Farm, is a clever and fraud person. He has similarly managed various bank managers elsewhere also and has amassed the loan amounts. We, Proprietor Jagaran Mancha, pray that all the accused persons be arrested under the Indian Penal Code and our loan amounts to our respective bank accounts. The loan amounts of all the members of Jagaran Mancha approximately would be 60 lakhs. How can we pay such a huge amount? As such, we pray your honor to take appropriate steps in law. On this, my lord, Telamara PS case number 169 of 21 was registered under section 420, 406, 468, and 34 Indian Penal Code. Now we had approached this honorable court for praying for anticipatory bail, and the order my lord finds at page 20 how it went through. The anticipatory bail was allowed. How it went through at page 20, if I may read it. I read the operative part of that. Page 21, the operative part of that. Let me read it.
Last but two lines. Last but two lines. No case is made out.
Well, option is page 22 or 20.
The case diary, it appears no criminal case is made out against the present petitioner.
Absolutely.
That is
number one. Anyways, so far as now, what happened is we had also filed an additional affidavit to bring on record three facts. Primarily, number one, these loans were insured. They had suffered loss. They have raised claims before the insurance. Insurance was repudiated. Thereafter, the HR followed. Now, what in substance, why I say on a bare perusal of the FIR, it should fall. My lordship, this example, I had been putting the illustration time and again, you know, if lordship permits. Suppose, this is not the first time. Suppose I would like to purchase a flat from a builder. Suppose I want to purchase a brand new flat from a builder. I would avail loan. The loan amount would be credited
to the builder.
This is what happened. We give the training and the apparatus and set it up. Therefore, the loan amount comes to us and we give it. Nothing more than that. They also admit it.
And now at page 35, they are admitting that the chicken could not flourish because of the storms.
And the worst possible thing, which I told my client, is at page 45. We had a thing that if you sell to us, they would not have suffered the loss. The other day, my client showed me that page 45 of the affidavit. Page 45. This agreement is valid for 12 months from the date of the chicken start laying eggs till the layers stop laying eggs. The second party under no circumstances will be allowed to sell eggs to others except the first party. The case.
This agreement happened, with this agreement, they did not.
So if they buy this, they would have gone. So once they rear and sell it to us, they would not even have suffered the loss.
It would have been your loss.
It would have been my loss. This is the circumstances, Milord. This is, I am on bail. There is no criminal case, is a factum on record. There is no challenge to that, even in the apex court. I put the question to myself, on the face of it, should I be facing trial? On the apparently case, it will be cost. And the Honorable Court has also touched that aspect. No criminal case.
All said and done is the note.
Much on the evidence part. I'm only on what is there in the Ajahat and what followed through.
You have the CD. Eh? We went through the entire matter.
Because we don't find the petition, Lordship. At the last one, I find a petition, which is wrongly written as 15 items.
If Lordship also considers this part, Milord, in this case, it is not on the police investigation. It is, I am on the.
Someone called for this. Some court called for the CD.
Yes, that is routine.
Can we now override that order?
Saying that. Lordship fixes it, takes up tomorrow, Milord.
Because the APP said that the CD is necessary.
Okay.
Why was the CD necessary in this case? Loan amount goes to their bank. They give the product. They give you the house. Like the example he has given, the house is given to the customer. The house breaks. How is the person who sold the house responsible? What is the criminal angle to the matter? And the chicken did not die of disease. The chicken died because the storm broke the cages. If it was bad chicken, still we would have said that okay, bad chicken. It's an act of God.
Act of God.
Storm comes.
On these things, Milord, Lordship may consider.
What about the respondent, the service on the respondent?
Yes, complete.
Yes. 1825. Tell us.
They are silent because they would not come.
If possible, Lord.
To do what?
To the CD mail.
When?
On any date, Lordship.
On any date will be a date when with or without the CD then.
May I pray?
On the next day it will be with or without the CD.
Then Lordship, on next day, if not CD will not be available, Lordship may take appropriate.
That is what I was saying. On the next date, with or without the CD, we proceed. Huh? What do you say, sir?
If the CD is so necessary, Lordship, I have to scan copy tomorrow.
Huh?
Scan copy tomorrow. They just scanned and said it's other in 3 parts. That they can.
We are not asking for scan copies in bail matters. Should we be doing it in this kind of matter? You are under a protection.
Under protection, but the otherwise it's quite embarrassing to continue with the because there is no stay order passed. On the same prayer that the CD will be coming. If that
This matter was, yes, take down. Heard Mr. Esbonic, learned counsel appearing for the petitioner. The criminal petition was filed in the year 2022 and by the order dated 22/12/2022. The case diary was called for. Today, the learned APP submits that the case diary is yet awaited. Eh?
6, Lordship.
Place the matter again on the 6th of March, 2026. Learned APP to ensure the production of the CD on the next date, failing which the matter will be taken up for consideration on the materials available on record.
I'm grateful, but obliged.
This is an application under section 482. This is an application under section 482, that with section 397 and 401 of CRPC. In this case, I have filed this application for quashing of the CR case, NIC case number 3777 of 2023, pending before the judicial magistrate first class. Now Gitartha Kumar, earlier it was Kaveri Puttachaji. In this case, I, being the complaint here.
Huh?
In this case, the petitioner, number one, company
Hmm.
is one of the purchasers of the respondent company.
Hmm.
And they deals in Philips LED bulbs and etc. So we have a business commercial transaction. In the meantime, the petitioner company had received a notice dated 28/4/2023
Huh.
from the respondent seeking an amount of rupees 50,000 for dishonor of check bearing number 0000810. After receiving the said check, Your Honor, the petitioner company has returned the check by NEFT dated 9/5/2023, which was received by the petitioner company. Received by the respondent number 2 actually. And the same was also notified to the engaged counsel who has sent the notice to the.
A check for 50,000 had bounced.
Yes.
And you had transferred that 50,000 amount by NEFT. Okay, then.
Days of the notice.
Then.
Your Honor, after the receipt of the payment, again the respondent had filed a complaint case for the
Can they?
Yes, Your Honor.
Eh?
In fact, in their case, they have also in their Your Honor, affidavit in opposition, they have also read. In para number 5 of the affidavit in opposition, they specifically mentioned that in the last part, Your Honor, they have received the check, though it is not made clear about the payment whether the check was of ledger amount account payment or against the check dishonor. My Lordship, they have sent a notice for dishonor of check of 50,000. After the receipt of notice, we have made payment of the same.
Yes.
Your Honor, actually, no one is appearing today. On the last occasion, they have withdrawn their wakalatnama. And
We'll see that this. We close this. Yes, tell us. We need some assistance from you. A little assistance. Caught off guard, but yes, still some assistance. You have a copy of the documents?
Yes.
Okay. What happens is this. Come to page 17. No, sorry, 16. Page 16. Yes? Give him your copy. Give him your copy.
Yes,
Have it?
yes.
Yes. Now, 50,000 rupees at the top.
Yes.
Check bounce 50,000 rupees. Now have page 18. 9th of May.
yes, Your Honor.
50,000 paid.
Date is 9th of May 2023.
Notice is dated 28/4. Received on 29th or 30th? At best? 30? Within 9 days? 50,000 paid. Yes?
Yes.
Now the affidavit filed by the respondents.
Yes, Your Honor.
There, if you come, page 25, it is not clear about the payment, whether it was of ledger account payment or against the check dishonor. They admit receipt of the amount.
Yes.
Simple case of harassment. Nothing else.
Yes. It's clearly indicated.
We'll pause the 138. The counsels were appeared for the main respondents. On the last occasion had sought for permission to withdraw from the case. Heard Miss?
Sahu.
And the counsel appearing for the petitioner also heard Mr. D.P. Goswami, learned APP. By the last order, the then engaged counsels for the respondent number 2 and 3 had made a mention that the file had been returned to the litigant and he and that Mr. K.D. Chetri was no longer engaged in the case and he seeks to withdraw the wakalatnama. The prayer was allowed by the court. The respondent number 2 and 3 were required to enter appearance today through new counsels. Full stop. The case of the petitioner is that when a demand for rupees 50,000 was made through the notice dated 28/4/2023 from the petitioners herein due to the dishonor of their check number 000810 dated 12/4/2023 drawn on the HDFC Bank Panbazar branch, Gauhati 781001, comma. The petitioners had made arrangements for payment of the said amount of 50,000 on the 9th of May 2023 by NEFT to the respondents. The respondents have filed an affidavit before this court where it has been stated that where the amount of rupees 50,000 is at a receipt of amount of rupees 50,000 is admitted, but a mere statement has been made that it was not clear whether it was a ledger account payment or against the check dishonored. Full stop. Since the amount of the check was rupees 50,000 and an amount of rupees 50,000 had been paid by the petitioners, and it is now an admitted position that the proceedings in the trial court had been initiated on a mere assumption that it may not be the money relating to the amount promised through the check, comma. This court is of the opinion that there is that the purpose of law would not be fulfilled if the respondents number 2 and 3 are herein are allowed to proceed to prosecute the petitioners herein on the basis of an assumption, and more so when the amount claimed by the check, claimed by the legal notice has already stands paid. Full stop. In view of the above, this court is of the opinion that the proceedings in
CR case number 3777 of
2023 in the court of the judicial first class or judicial magistrate first class under section 130 of the Negotiable Instruments Act 1881 does not require to be proceeded with and therefore stands quashed. Criminal petition disposed of.
Obliged, Your Honor.
Yes, sir. For a start in the merit of the case, my lord, actually after filing of this case, instant case, someone in respect of another criminal proceeding was received by the petitioner, which was challenged before this honorable court by way of another criminal petition 1535. And therein, my lord, a order was passed on 28/1 that this matter along with that matter may be taken up together. But however, that matter was listed today before another honorable bench, and that has been now been mentioned and will come up after 2 weeks. Otherwise, if your lordship pleases, this is an independent matter. Whatever order is passed herein will prevail in that case also. So if your lordship pleases, I may make a submission or maybe taken up together. Since
no, if there is an order in that case, then it should be listed together with this.
That is why
let us honor the
yes, my lord, because order is not passed in this case.
Issue is, my lord, same.
Issue is same. Otherwise, it can be taken up together and disposed of together. Otherwise, even if matter is taken up today.
What do you say?
My lord,
What do you say?
my lord, issue is same, my lord, in that petition also.
Pertaining to the same land.
It was, my lord, mentioned today, my lord, in code number 14, my lord. But maybe taken up together.
Yes, one may be heard.
List along with criminal petition number
1535 of 25.
My lord, I have another prayer, my lord. My lord, my lord, in case I have perused the scan copy, my lord. Last occasion, my lord, on it is 27/8/25, my lord, last order, my lord. That is for my lord report and my lord appearance. Then my lord report may come to that court
in this time, my lord, within this time, my lord. So that report is, I think, my lord, it will be necessary for disposition of this case, my lord.
What report?
My lord, kindly have a look at, my lord, order dated 27/8. My lord, it has scan copy, my lord.
Scan copy ki order ase so.
I have flag mark, my lord. That report, my lord, in the meantime, my lord, that report may come to the, my lord, honorable trial court, my lord. If it comes, my lord, then that may be called from.
What report?
My lord,
Offense report is already on record.
no, no, that is not offense report, my lord. That
What
land
report?
land is between, my lord, Assam and Arunachal, my lord. Whether that land belongs to, my lord, Assam or Arunachal, my lord, that is the, my lord.
From where do you find that is the kind of report you want?
That report.
On 30/11/2023, any other relevant records along with so and so along with offense report.
Offense report is
Then on 4/10/2024, fixing 7/12/2024 for appearance / report.
Report.
What kind of a report? Call for the report. What report?
Yes, my lord, that is.
Medical blood test report of the.
My lord, there is an interstate
No,
border
in the
dispute.
meantime, what?
My lord,
Where
that
is it
reflects from my
recorded?
annexure 6, page 40 of my petition, my lord.
Sir, he is asking for the report to be called for. What report?
That is what I am asking.
Whatever it may be, my lord, that is called by the honorable trial court, my lord.
What report?
And
That is what we are asking you for appearance and report.
that is.
Tell us what report,
No,
blood report.
I know. The observation is.
Then how do you know what kind of a report?
That is, my lord.
They may dispute by filing an affidavit that what annexure 6 I have annexed is not true.
You want to produce some report, please produce some report.
My lord, scan, my lord, to registry, my lord.
Who will give the report to the
because it
lower court?
Because, my lord, it's report of
Who will give the report to the lower court? Call for the report. Who will give it? We assume it is the report that.
If, my lord, any report, my lord, is, my lord, received by the trial court, my lord.
Sir, who has to give that report?
It is not a vague, that is not clear.
So what vague thing can we call from? You are asking us to call something, sir. Tell us this is the vague report I want. I don't know what report I'm calling for. Call for a report. Then for that report calling, it will go for another 6, 7, 8, 10 dates.
Well,
Since this court has asked for a report, let us honor it. Call for the report. Call for the report. We'll simply keep writing call for the report.
Updatation of the, my lord, scan copy maybe, my lord, yeah.
Hey,
There is anything
you
developed.
kindly get certified true copies of everything that is there in the record. Can you do that? Get certified
Offense
copies.
report and the
No, whatever is there in the file.
order of the cognizant, that certified copy I have already
What
annexed, my
more?
lord.
It
I
is,
cannot obtain any other document, my lord. That is not within my domain.
Then what more?
it is up to, my lord, 11/11/25, my lord, scan copy.
Scan copy of the
During this
LC.
time, my lord, some.
Thereafter, there is an order saying that now the court has stayed it.
Scan copy
Sorry.
of the TCR can be called for only.
For what? On 26/8, further proceeding in 15/23 is kept in abeyance.
Yes, my lord.
Then
Scan
there is
copy
no
of that
development.
record only will come.
So what scan will come? After 26/8,
Other
nothing
than
has been done.
No.
No scan copy required. And if there is a report, tell us the authority who has to
Because
give
it
the
is
report, we
already
will get the
stayed.
report. Huh?
Already stayed.
You said there is a report. You want a report. Report of whom?
No, my lord, I am quoting from, my lord, that order. My lord, order is at 25A.
What report? Tell us that this report from the forest department, from the Arunachal government, from the Assam government, from the national highways, from the forest Arunachal department, from the central forest department, something tell us a report. Simply report and these things. What did you say? List along with?
criminal petition, my lord, 1535
Oh.
25.
Hey, Harry. আধা অৰ্ডাৰ সিজনে লৈ গ'ল so it will be list along with
criminal petition, my lord, one five three
Chak
five
mana koi dibo maribo. Ha. Criminal petition number 1535 of
2025
2025.
after 2 weeks.
After 2 weeks hoibo pai ne itu date nidile.
That matter is fixed after 2 weeks.
Ekelage di dibo. Thik. Okay.
Highly object.
And even now, if you have any particular report that you want to call for, we will still record it in here. Tell us what report. Calling for reports, it does not help. It is only burdening litigation. Or you dispute the documents he has given.
Yes.
It is for you to dispute. You are the forest department.
My lord.
You are the PP forest department. Then you dispute it. Interim order continues. Converted to bail cancellation.
Bail cancellation, my lord, on principle, my lord, I am submitting.
50.
Along with 50 means, my lord, that is the objection filed by the other side, my lord. So that was registered as a miscase, my lord. Is it correct? You filed a IA, sir. IA. No, that's not IA. That is actually objection. Actually, my lord, what happened in this case? CD is required. Bail was rejected. I am the complainant. Bail was rejected by the Honorable Court. Then went to the Supreme Court. Supreme Court rejected, my lord. Then, my lord, they straightway filed an application before the session court, my lord, session on a medical ground, and session court granted bail. So, my lord, if the medical ground, my lord, they have filed an application, they should have filed here, my lord, but it was not done. But I am not on that now, right now. In the meantime, my lord, there are two accused, husband and wife. Fraud is about, my lord, 3.6 crore rupees. That's big amount, my lord. They have taken a loan, showing a plot of land, which is already sold out twice. My lord, that was connected with another case. So now they are not paying the money. So we lost an FIR because for this is fraud, my lord, and case was registered. And both of them are their anticipatory bail, and by this time, my lord, one of the accused died. So so far his wife is concerned, it is remain now. So, my lord, CD is required. Whether CD is available or not, my lord. And if it is now, my lord, already submitted, definitely I will not going to. But there is some observation, at least, my lord, that why, my lord, that case was rejected by the Honorable High Court, by the Supreme Court.
Was it placed before the trial court?
It was placed, my lord. Placed, we pinpointly object also, giving the order of the High Court also.
Thereafter, it was allowed.
And then on medical ground, husband was on medical ground, no problem, my lord. But priority demand, that this filed the High Court, my lord, because in Kamrup, my lord. But anyway, my lord, now, my lord, you have to kindly see the case there. In what stage it is, my lord? It is from Polton Bazaar. It is from Polton Bazaar police station, my lord.
Yes, when can you have it? From Gauhati, it is not coming up. Huh? The CD would not come up, or whether it is charge sheeted, CD, what happened? Huh? It is charge sheeted?
Not charge sheeted.
Not charge sheeted. Then, why is it not coming up? Huh? When will it come? 19th? 9th.
Well, no problem.
Can we have it on
I'm
the
available, but only accommodation is required. Well, sometime I mean other court, my lord, that
Yes, 9th. On the list again, I heard Mr. T.J. Mohanto, learned counsel appearing for the petitioner. The learned APP shall ensure the receipt of the case diary in the matter. Mr. So-and-so appears for the respondent number so-and-so.
with 50 also goes.
Huh?
Item number 50.
Along with item number 50 detail. List along with?
Because their objection is separately registered.
Your objection is separately registered.
I have filed one IA lordship to bring on record certain documents. This subsequently registered. That is listed as item number 50.
Item number 50 lo diok, list along with item number 50 di dibo, ha?
Develop.
Just come back in 2 minutes. Huh? 9th? 9th of March.
There's some accommodation, maybe some instruction.
CD is available, but CD is available. We need to update that.
You want to update? When do you want it?
If Monday, then it may be retained.
But otherwise, he wants an updated. So
If he wants to update, then that is different thing. If he wants to update, then we will have it on 9th.
9th. Updated by 9th. The Learned APP shall have the updated CD by 9th. Mr. NJ Dr. Learned Counsel appealing for the petitioner pays for an accommodation. List on 9th of March.
I'm obliged.
Yes, sir.
My lord, Jason, I was arrested on 8/12/2025, my lord. And before that, my lord, I just want to draw your lordship's kind attention to the order dated 5/1/2026 on page 30, my lord. On page 30, my lord, I'm just reading out the relevant portion for lordship's kind convenience, my lord. Only the last 5 lines, my lord. The case diary has not sufficiently progressed and the investigation is in a very early stage, and therefore considering the early stage of the investigation and the nature and gravity of offense, the instant bail application for accused Srimati Phagoni Basumati stands rejected at this stage to facilitate investigation, my lord. Now, my lord, I am not the main accused, my lord. I am the wife of. Now, I just want to draw your lordship to take a lordship to page 10, my lord. Page 10, my lord. On 9, I'm just reading out the relevant portion, not taking more much time of lordship's valuable time, my lord. On 8/12/2025, Orang police received information about a large quantity of suspected ganja and stored at the house of Metinga Doimari. Metinga Doimari is my husband, my lord. I am not the manicure, I'm the wife of, I'm wife meeting a Doimari, my lord. So on the basis of that, the contraband was recovered from me, my lord. And my lord, I was also having a child of 7 years who was also in jail with me, my lord. And my child is also, my lord, is undergoing medical treatment from jail, my lord. He is also missing his school days. And my lord, grounds of arrest, the main point is that the grounds of arrest has not been communicated to me, my lord. In this regard, my lord, I just want to take your lordship to one of the very charismatic judgment of the Honorable Supreme Court, Gurmeet Singh versus State of Punjab, 2025, SCC online, Punjab and Haryana 849, my lord.
The husband's name is?
Mithinga Doimari, my lord.
Mithisar.
Mithisar Doimari, my lord. So in this, my lord, so para 4, the judgment para 4 is important. I will not take lordship much valuable time. Only the relevant point I am reading out for lordship kind convenience. Para 5, my lord. To put it shortly, a human attitude is required to be adopted by a judge. While dealing with an application for remanding a suspect or an accused person to police custody or judicial custody, there are several reasons for this, including maintaining the dignity of an accused person, howsoever poor that person might be, the requirements of the Constitution, that there is enormous overcrowding in prisons, leading to social and other problems as noticed by this court. in rehuman conditions, which your lordship is very well aware of it, presence. So my lord, that is also, and my lord, in para 4, it has been specifically mentioned, my lord, surely if an accused is not hiding from an investigating officer or is hiding due to some genuine and expressed fear of being victimized, it would be a factor that a judge would need to consider it in an appropriate case. It is also necessary for the judge to consider whether the accused is a first-time offender or has been accused of other offenses, and if so, the nature of such offenses and his or her general conduct. The poverty of the deemed indigent status of an accused is also an extremely important factor for deciding bail, my lord.
Yes.
And, my lord, I just want, already I have spent my lord 2.5 months in jail, my lord. And that there is also one Birhan Kumar, who is a lord, she is very well aware of the Pankaj Banshan and all that, my lord. The grounds of Alice has not been communicated to me. I only know my lord's Boru language. I do not know aspects of any Hindi language of English, my lord. I'm totally dull about this, my lord. And the grounds of arrest in Boru language is not communicated to me. I am not sure in which case I have been arrested, on what ground I have been arrested. So, my lord, the CFPC, the BNSS has given your lordship an ample power to grant me on bail. If allowed to go on bail, my lord, I can assure your lordship, your lordship's every order, your lordship's every directions, your lordship's every restrictions that will be imposed on me will be followed in letter and spirit, my lord. That is my humble prayer, my lord.
What about the husband arrested?
No, my lord, no, my lord.
Not lordship.
No, my
Husband still running around?
Lordship.
husband is my lord. I do not know myself. I do not know myself. Where is he, my lord? Honestly, confess.
Yes, what does the CD say?
Honestly, confess. my lord.
Lordship, in the seizure, I have found that they are husband and wife and things, 50 kg ganja, Lordship. With a commercial.
Thereafter another 25 kg.
Lordship.
Thereafter another 25 kg in the abandoned house.
Lordship. But in the bedroom in the bed, Lordship, under the bed, it has been found. And Lordship, moreover, in her statement, I have seen that this person, Lordship, the accused person, the husband, has earlier also gone to jail. She has stated, Lordship, and she is also doing this business, Lordship. And moreover, Lordship, so in her conscious position, it has been found, Lordship.
So she should have informed the police that her husband is doing this business. Or she should have told the police, husband, that I will not help you. It will be too drastic on her part to do. Huh?
It is aware, she is aware of her mistake.
She's aware. But was she competent to
It will
resist?
come in the evidence stage, my lord. Now
Was she
it's not the-
competent
not the
to
point.
resist? Now it is how many days?
Almost 2.5 months, my lord.
Section 37 also is there, Lord.
Huh.
Embargo is also there.
Embargo, total embargo.
Lordship.
Where is the 48 notice?
48 notice is there, Lordship.
To?
Lordship, I have flagged mark.
To whom?
To Lordship, to herself is 47
Huh?
and to 48 Lordship, one Thaneshwari Basumatari, Lordship. She is there.
Let us see. Who is she? Let us hope she is not a WSI. She is not a WSI of the same police station, hopefully.
My lord, my lord.
If she is not conversant with any other language, how she signs in a different language?
My lord, I only know, my lord, Boru language, my lord, honestly.
But she signs in a language other than Boru.
My lord, only sign, but I can sign.
Boru does not use, Boru uses English alphabets.
No, my lord.
Is it not?
In Udalguri district, Boru is popularly known, my lord. It is
The vernacular is Boru, but when they write it down, how do they write it down?
In Boru.
There is a different script.
Different state.
Boru script is there.
Different state, my lord. Udalguri, there's a different state, my lord.
But she signs in Hindi.
It is Hindi, it is written, my lord. Sandra, they also know, only the signature is written.
Just a minute. Script এইটাই ইউজ কৰে তো দেৱনাগৰী আৰু ৰোমান দুইটাই ইউজ কৰে ন হেৰি ইউজ নকৰে তাহাঁতৰ নিজৰ কোনো স্ক্ৰিপ্ট নাই দেৱনাগৰী ইউজ কৰে দেৱনাগৰী Okay. Who is this Dhaneshwari Basumutari? Huh?
It's not there, Lord.
Who is this person, Dhanesh
I do not, I
Story
don't know. but
Basumutari?
Personally, I do not know, my lord.
Hmm?
I do not know, my lord.
912. 912.
But in the petition, Lordship, section 47, in petition, what I have seen, Lordship, the question of 47 is not raised,
In the bail petition.
Lordship.
So we will go like this. Hands are tied. No. When was she produced before the remand magistrate?
Special judge, my lord. Udalguri.
When?
On 9/12/2025, Lord.
9/12.
2025, Lord.
Page 30, my lord. Page 30, my lord. Ordered at 5/1/2026, my lord.
Hmm?
Page 30, my lord. Page 30. Ordered at 5/1/2026, my lord.
We'll have it at 2. Find out who is this Dhaneshwari. 48 on whom it has been given. 48. They must have.
After some time, Lord, I will.
That is one part. Second part is the arrest memo. The time of arrest has been shown to be on the 9th at 10:30.
My lord, my lord.
But the case diary reveals that by 8:10 p.m. on 8th, you had all reached there.
My lord.
Is it not? Where is the arrest memo? Dhaneshwari Basumutari is the name of the relative of the accused. But that is at 12:10 p.m. arrest. Same day produced on 9/10, 9/12.
On 9/12, Lord.
So even if it is late night in 8/12, that 9/12 part, that 24 hours is covered. Dhaneshwari is shown as a relative of the accused. Yes, we don't find much.
But I can assure lordship.
47 is your language part.
Moreover, Lordship, in the production, Lordship, Art Learned Counsel for the accused.
Huh?
Our accused is also there, present.
Counsel is there.
Counsel is there, Lordship.
That isn't.
Otherwise, how can say no?
Then the
Lordship?
counsel should have raised the ground that yes,
Raise the
47 not
ground.
there, 48 not there, not understood.
Udalguri court, my lord. That is in Udalguri.
Ah.
That's in Udalguri court. I do not deny this, my lord. Only I can pray before Lordship, my lord. Main accused.
If
is
we are,
the
if
main
we are
accused, my lord.
evaluating it on a court to court basis, the prejudice will be evaluated in the Udalguri court basis,
No,
not on the Gauhati court basis then.
Not my, I am not on that, my lord. Only my lord, I can say, my lord, I am not the main accused, my lord. That,
You are.
That is perfectly.
You are, your statements have led to the recovery of another 25 kilos.
And my lord.
Along with weighing machines, polythene bags,
And my lord.
ready to pack and deliver.
My boy is with me also, man. He is
Your boy is
missing
suffering
school.
nothing. Sorry, your boy is suffering nothing. Can you show us what is he suffering from?
No, he's missing school days, my lord.
He will, his father will take care. His father goes in, he will come out, no problem.
So, my lord, I can only pray, my lord, for lordship grants to Indian, my lord, your lordship.
If there was a son who needs to go to school,
My lord,
the mother and father should have been careful.
but I do not
That
know
is the
my-
best we can say.
where my husband is.
Because the JJ hospital, Dhekiajuli part, giddiness, headache and vomiting. Hemoglobin is 9.2, of course, on the lower side. Everything else is exactly what it should be.
I leave it to your lordship.
The
my lord.
report
I leave
would
it to your
say
lordship, my lord.
no detectable abnormality in the whole abdomen.
I leave it to your lordship, my lord. I leave it to your lordship, my lord. Only, my lord, your lordship has got ample power, my lord.
If
It
your-
leaves
if
from
your-
jail, my lord,
If
then
your
I can
husband
escape
had been
lordship, my lord.
cooperative,
I will abide by your lordship's any order, any directions, any restrictions that would be for given on me that I will be
the
following.
husband is yet, he's yet missing.
Not arrested, Lord.
We'll have it at 2. Find out about whether the husband has been apprehended.
My lord, man.
Huh?
If possible, I will, before 1, I will Lordship, look into that.
If you're here for some time, let us find out if the husband is there, we'll consider on that aspect.
My
7-year-old child alone at home.
I'll look into that.
But otherwise, if the husband is running around, let him take care of the son.
So,
Bane of the society. Here the charge sheet had been submitted.
Petition has been informed. It's not a charge sheet, but a closure report has been submitted. Charge sheet's better
If it
the
is a closure
is-
report, either which ways, since a final form has been submitted, we make the AB absolute, giving the liberty to
But here-
approach in case she is summoned.
But here charge sheet stated, Lordship. Charge sheet. Right side
Either
is
which ways, it's a final report,
Final report,
final form. What do you call it? The final form.
final form.
If it is the final form, the AB will be made absolute. And in case you receive a summon, you would have to appear before the trial court for regular bail.
Closure, then it has been.
If it is closure, then you will approach only if you receive a summon.
Lordship.
Is it not?
Lordship.
Okay, heard, miss. Mulwa for the petitioner also heard Mr. So-and-so learned counsel appearing for the as the APP. It has been submitted by the APP that a charge sheet has been submitted while it has been contended by the learned counsel for the petitioner that it is a closure report. In any view of the matter, since a final form has been submitted, it is not in dispute that a final form has been submitted to the in the matter, comma. This court deems it fit to make the absolute, to make the interim protection granted to the petitioner absolute. The petitioner would be at liberty to approach the appropriate court in case summons are received in connection with any proceedings related to
Juria PS case.
Juria PS case numbers
27 of 2020.
11/2025 25 order to আছে Juria PS case number AB disposed of. Huh? Petitioner was an interim. It has been submitted by the learned APP that the charge sheet has been submitted in the matter. In such view, the interim bail granted to the petitioner is made absolute. AB disposed of.
Charge sheet number maybe.
Charge sheet number
Hearing Lordship 01/26 dated 18/01/2026.
Any other accused in this matter? Charge sheet 01 of 2026. How many accused are there?
Other cases are arrested.
Only one. Only one.
No, Lordship, it is not written here.
Number of accused?
Number of accused is.
In the charge, in the FIR, how many accused were there?
FIR. There are three. Three accused.
See, why do we remember? 1 of 2026.
Lords.
That time we thought, oh, the first charge sheet. In another case, this is involved. Before. Yes, sir.
My please, your lordship.
Ah.
My lord, it's a substituted case, my lord. Offense, my lord, connected with 22B of NDPS Act.
Ah.
My lord, petitioner is ready to cooperate with the proceeding, my lord. 3 years bail may be granted, my lord.
He was put up for trial.
My lord, is an intermediate quantity. And his name is not, my lord, in the, my lord, just because item recovered from him, my lord. His name appeared in the, my lord, FIR just because the co-accused arrested person stated that he procured items from the, my lord, petitioner. And my lord, the statement of a co-accused cannot be considered as a substantive piece of, my lord, evidence against another co-accused.
Had you cooperated in the investigation, they would have been.
Lordship, he is shown as absconder, and against him, Lordship, BW is issued. From the charge sheet date, Lordship, till now he is not appearing. He is absent with steps, Lordship.
My lord, he's
Absent with steps.
On last date, on many occasions with steps, but on the last occasion, the court has stated that this time you have to appear, and that is why the court has issued BWA, Lordship. That is bail order.
When is the next date?
Next date is 21/02/2026 for appearance.
2102 gone, sir.
No, my lord, 25/5/2026.
25/5/2026.
And his counsel is appear, my lord. Only, my lord, his physical appearance is required, my lord. I am ready to appear, my lord, next date, my lord. Or, my lord, before, my lord, immediate before.
Yeah?
Otherwise, Lordship, he is not appearing, not cooperating.
No, if we force him to appear, and custody is one.
Oh, as there is a BW is issued against him.
Oh.
He may appear, Lordship.
BW, my lord.
Bailable warrant is issued.
It's an NDPS case, my lord. The apprehension is there, my lord. I may be.
Apprehension will be there. Why have your name entangled in such things?
That may be, my lord. And my lord, in this case, my lord, Honorable Supreme Court judgment is there, my lord, regarding the, my lord, apprehension.
Saying what?
He may appear, Lordship, and
Magdum Baba, my lord.
Huh?
He may appear, Lordship, and trial court.
I am ready to appear, my lord.
As per law, Lordship.
Oh, we are not considering his appearance to be put to jeopardy.
9 and 12, my lord.
We will ensure that he continues to appear.
I am ready to appear.
In this case, primary focus is on documentary evidence.
My lord,
For NDPS, what kind of a documentary evidence are you depending on, sir?
my lord, another.
9 Roman 3, huh?
Another case, my lord, from this honorable court, my lord.
Mr. Goswami, take a look at paragraph 12. Let us just see. Another what?
Another one from this honorable.
Why in piecemeal manner?
Here, my lord, since the petitioner interested to cooperate with the proceeding, my lord, he was granted bail, my lord. Para, my lord, 6, my lord. Similar orders.
That is a POCSO case
Also, is a special case, my lord.
against
Yes, my
one
lord,
particular individual.
consequence is more serious in POCSO case, my lord. And here is, my lord, intermediate quantity. And my lord, contraband items is from the another person, my lord, not from me, my lord. Kindly see the affair.
You are the bigger fish.
It's a statement, my lord.
Now, since you make submissions, we also, that is not playing in our minds in any manner.
No, this is just, my lord, I'm ready to cooperate, my lord.
Hmm?
This case, Lordship.
Documentary evidence we see.
The accused were present during the investigation and they were not arrested. That's a different fact, Lordship. They were present during the investigation and they were not arrested.
Not
but
arrested.
It is a different fact, Lordship.
But apprehension is there, my lord, in para 9 and 12.
No, it cannot be said, Lordship. And Lordship, this respectfully, I take offense to that statement that I am willing to appear before the court. He is bound to appear before the court, Lordship. It is not a question of Lordship willingness.
No, the willingness is that I will not be required to be forced.
So I am ready to appear.
No,
before Lordship.
no, even ready to appear is, I will not be required to force. I am ready and willing, sir. That is what he is trying to say. It is not about that my arrest will not be required. I am anyways willing and ready, sir. I will come every day is what he is
Even
trying
if
to
Lordship is not willing, he has to appear. He is bound.
Then he has to be forced.
Yes, yes, Lordship.
And he says that prior to the giving the force, I will willingly do it. That is the submission.
The AB rests on a primary foundation, Lordship. There has to be some apprehension.
They,
Investigation is over, Lordship. Where is that apprehension? Apprehension part, only bailable warrant has been issued. That it is not safe to say, Lordship, that the court will take me into custody. The court may also grant bail. Where is the dividing line, Lordship?
we can observe that part.
Yes.
We will say that you would cooperate with the BWA.
Yeah.
Give your bail to the, give your assurance to the investigator, to the arresting authority or whoever you have to satisfy. You go and satisfy them. Appear in the next day before the trial court. Anyways, you are not being arrested before that.
Yes.
And we'll make an observation that on your appearance, that you have appeared on receipt of the BWA. The court will seriously take into consideration whether your custody is required for you to continue into trial or not. I will decide your petition.
Amongst other things.
Otherwise, everybody stays away during the investigation, then during the trial, they come and say, we'll face trial. If the charge sheet can be, if a person can be away from the investigation till the charge sheet point of time, thereafter it is simply staying at home and going and appearing on particular 2 or 3 months.
If liberty is given,
And these persons are free to roam around all the state to
if liberty
carry on what 37 NDPS tries to stop. These people get the leverage out of it.
if liberty is given, my lord, in full.
No, we are not giving you liberty. We are directing you to satisfy the conditions of the BWA. What is a BWA? You will not be arrested. Before the police station, you will say that, okay, I will appear. They will take some surety and let you go. They cannot retain you. They cannot detain you on a BWA. So till May? 25th of May.
Next day, 25th of May.
Till 25th of May, you have no this thing of arrest.
Or before your lordship, I am ready to.
Is it not? You go in with that, satisfying that condition, go and appear before the trial court. We'll make an observation here that since you have, if you, in the event that you take in, you comply with the BWA, the learned trial court will further decide whether your custody is in fact required for the trial or not. They'll give reasons why they want to keep you in custody if they want to. Is it not? Let the trial court have their say. At least till 25th of May, you are not in any trouble. Appear before that, since you are appearing with a BWA. And I think there is one case where since the date was fixed and he was trying to appear earlier, he was not allowed. This court had said that no, you can appear even before that if there is a BWA. That has been decided by this court in some matter. That it is not only on the date of appearance you need to go. In these kind of cases, you can go earlier also to say that, look, I will participate. I have come. I'm still on bail. Allow me the appeal. Trial court has to take that into account.
But if is, my lord, the liberty is given to the, my lord, trial court, my lord, then there will be no meaning of pre-arrest bail, my lord.
Obviously.
Whereas the, my lord, in Gurboxing, my lord, the pre-arrest bill can be filed at any stage, my lord.
Yes.
On the basis of your lordship. may decide
Pre-arrest
some
bail, is it necessary that only we will consider?
Yes, your lordship, if there is no material
Pre-arrest
against me, my lord.
How do
If-
we say that? Then
if
we
there
will have
is-
to evaluate the charge sheet.
If there is no material prima facie
Then we have
against
to
me, my lord,
evaluate the charge sheet. Or the truth of it. If we decide against it, it will be to your disadvantage. Should we embark on that journey? We are trying to see both sides, sir. You see it from your angle.
my lord.
We see it from both angles.
That is why in the judgment, my lord, Rakibul Islam, that is, my lord, I have given your very lordship, my lord. My lord, since the petitioner is interested, para 6, my lord. His bail was granted, my lord, by the honorable court, my lord, this court, my lord. Kindly see para 9, my lord. And the surety almost all are fixed, my lord, from this court, my lord. Is a, my lord, special court trial case, my lord, POCSO case, my lord.
What was the amount recovered? Intermediate.
The similar order may be given, my lord. I am ready to even.
What was recovered is intermediate. But what you may be handling may be.
Kindly see the seizure list, my lord, whether product recovered from me or my lord to some other person. If my lord recovered from me, then my lord I am involved in this case. Just because the statement of a co-accused, my lord, cannot be, my lord. Kindly see the, my lord, on judgment, my lord.
What do you say to this, Mr. Sharma? He's producing it before us. Where is the BWA?
BWA, my lord, but
The order of BWA? It is here. What is this?
My lord,
Regarding?
regarding the, my lord, the statement of a co-accused, my lord, there are 13 and 14, my last page, my lord.
Whose bail petition is whose this page 30? Page 30 is what?
Page 30 is the, my lord, arrested person, accused number 1. From his possession, my lord, contraband.
He is now on bail.
My lord, he is on bail, my lord.
The trial is going on.
Trial
You have not
because
appeared.
appearance is required, my lord. Trial you have to start.
In the trial, when he has appeared,
My lord,
he has not been taken into custody during trial.
no, my
Why do you apprehend?
He has appeared through his counsel, if I'm not wrong.
lord. Yes, your lordship.
Uh-huh.
He has appeared.
He has not appeared physically.
I'm not on that. What I was inquiring is, when the person from whom the contraband was recovered
He was arrested.
has been allowed to remain on bail by the trial court below, why is he apprehending that he will be taken into custody
His bail was granted because he was arrested.
during
And
the trial?
after mandatory period, he was, my lord.
During the trial?
Yes, your lordship.
During the
No,
trial?
trial is yet to be started.
During investigation, he was given the default bail.
Yes.
During trial, does he not need to continue that bail? Or it remains just like that?
Previous bail, my lord.
Remain on previous. So there is a bail application. He was allowed to remain on bail
Yes.
during the trial. That is what I'm saying. Why are you apprehending arrest? When the main accused is on bail, why don't you point it out to the trial court that I don't need to be on bail? We will be usurping all their powers otherwise.
Observation may be given.
We'll give all the observations which will facilitate the trial court to consider your bail.
Yes, your lordship.
But granting it from this table is what something we are apprehensive of. Because this may lead to a situation, in our opinion,
My lord.
if you escape the investigation part, during trial you can just come and have an anticipatory bail. So during the entire fiasco,
Well, sometimes
during the entire fiasco, this man who is selling it actually, maybe, does not face anything.
Trial will prove, my lord, that is, that is.
The moment the
but
trial is there.
this, I have never charged, my lord, in all the past.
That
year,
is
my
why
lord. That is why.
they
I
don't
have
want
not-
you in.
Except, my lord's receipt of summon, my lord, I have no knowledge prior.
We will observe that the main accused from whom the recovery is made is on bail. We'll observe everything and then we will have you approach the trial court
My lord.
on your convenience on the date fixed or even prior to that.
Right, my lord, anytime.
And since you would always, you would have already complied with the conditions of the BWA, that will also be taken into consideration. And the trial court would thereafter decide the requirement of your custody, if any, or whether you can be left on bail with proper sureties so that you participate in the trial. Since the other accused are already outside, why have you behind? We'll make those observations. But we don't want to take away that power and give an impression that if you are out in the investigation period, an AB petition at the end of the day would solve all issues. Like you were showing us some things. These judgments will also be shown that now it is coming in the NDPS also. It was there in the POCSO, now it is there in the NDPS. We don't want that impression to go. Your client may be very innocent, but there will be people who will be taking advantage of these orders. It's something we do not want our signatures to be there. Huh?
I leave it because.
But we'll ensure that
Some protection.
enough security is given to you. Heard Mr. Svensson and a counsel appearing for the petitioner. Also heard Mr. Sharma and APP. This is a bail petition under provisions of section 482 of the BNSS 2023 for granting anticipated bail to the petitioner. The crux of the matter is that the petitioner is one of the accused put up for trial in connection with. Where is that?
My lord, in connection with.
Special end case number 173 of 2024 under section 22B of the NDPS, which is pending trial before the learned special judge South Salmara Mankachar, arising out of Mankachar PS case number 270 of 2023. The learned counsel for the petitioner has submitted that during the course of the investigation in the matter, the petitioner had not been sought for by the investigating authority. Although he has been shown as an absconder in the charge sheet, it is settled position in law that the investigating authorities are not authorized to declare a person an absconder. Full stop. The case of the petitioner, according to the learned counsel for the petitioner, is that he was not required by the investigating authority at any point of time to appear before them, and therefore he never had knowledge about the pending investigation or the police case. Full stop. However, on receipt of the summons, the petitioner had made his inquiries, and on coming to know that it is a matter of relating to NDPS Act, he had requested he had engaged a counsel to represent him before the trial court, who, as per the orders already annexed to the bail AB, would show had appeared and sought for time for appearance. By the order dated,
Order 38, 2023, other accused.
Where is the BWA?
BWA is not annexed in my petition because it was perhaps in the last order, my lord. It may be, my lord, on 5/12.
By the order dated 11/9/2025, the trial court had allowed the prayer of the petitioner herein as a last chance and required the accused persons to remain present on the next date fixed without fail. On his, the APP has submitted that on his failure to appear on 5/12/2025 also, bailable warrants of arrest have been issued against the petitioner herein. Full stop. This AB had been filed on
Everyone filed on, my lord, 6/1/2026.
6/1/2026. 6/1/2026, after the bailable warrants of arrest had been issued against the petitioner. This court notices that the effect of the bailable warrants of arrest issued against the petitioner would be that the petitioner would have to give appropriate surety for his appearance before the learned trial court on the next date, that is on 25/5/2026. Full stop. The bailable warrants of arrest do not authorize the arrest of the petitioner to secure his presence before the trial court. In such view of the matter, this court directs the petitioner to comply with the conditions of the bailable warrants of arrest and appear and give appropriate surety of his appearance before the learned trial court on 25/5/2026. Full stop. The learned counsel for the petitioner has submitted that since the matter relates to NDPS and he has been shown as an absconder during the period of investigation, the trial court, and there is an apprehension that the trial court may direct him to be taken into custody during the period of trial. Full stop. This court has noticed that insofar as the co-accused from whom the contraband had been seized has been allowed to remain on previous bail by the learned trial court during the period of trial. Full stop. The co-accused was earlier granted a default bail. Granted default bail on 30/8/2023, and even during the period of trial, he has been allowed to remain on previous bail. Full stop. This court is not convinced that the learned trial court would direct the petitioner to be taken into custody as a matter of course, but would rather consider the circumstances and the sureties being given by the petitioner for his participation during the trial before considering whether the petitioner is required to be taken into custody during the period of trial or not. In such circumstances, if the petitioner appears before the learned trial court after having complied with the conditions of the bailable warrants of arrest issued against him, this court, the learned trial court would take into consideration the entire circumstances and the assurances and conditions, etc., given by the petitioner for his participation in the trial before taking a decision regarding the requirement of taking the petitioner into custody for facing of the trial. Full stop. In case the trial court is of the opinion that the petitioner would not abstain from facing trial, it is needless to say that the trial court may put such conditions upon him to ensure his participation in the trial. Yes, we have left it entirely to the trial court.
One submission, two submissions basically. One submission is also, my submission may be recorded, that the FIR incident is of 2023. Charge sheeted, he was not present during the investigation.
We have already said so.
Yes. Second observation, the trial court will consider the other aspects of bail also.
Yes, everything. We have simply said that if he complies with the bailable warrant of arrest, he gives his sureties for his appearance, and thereafter, if he appears, before deciding whether his custody is required or not, the trial court will take into account the entire circumstances, along with his assurances, before deciding whether his custody is required or not. So now the trial court has to say that this is why I think that he should be in custody during trial. Already the entire charge sheet is there, the evidence, everything is already fixed. Unless if the trial court comes to a conclusion that no, this is a dangerous man, I know him personally, and he will go and make all the witnesses run away, this and that.
Conduct has to be seen.
Everything will be seen by the trial.
From 2023. He did not participate, so that is a very important factor.
How can you expect a man of the stature of his client to willingly participate in a investigation like this?
Can't help it, that is an important factor for granted.
Willingly, no one participates. Anyway, we have left it to the trial court.
The date may be fixed for it.
No, it is already on 25th of May. We will not interfere with that date. Let him comply the bailable warrant of arrest. Thereafter, let him approach the trial. Is it not? Anything more required to be recorded?
No, my lord.
Huh?
No, my lord.
We
because
don't want to take away that power in this case, in NDPS case. Let the trial court decide on a case-wise basis this man requires to be in custody or not. Yes, next. Disposed.
Lee oblige your lordship.
30? Time being.
Kilo 30.
Lordship, I have seen as per the last entry 25-2. That is tomorrow, yesterday, Lordship. He was not arrested, Lordship.
He's not arrested.
Not arrested.
And my lord, his bail petition is, anticipatory bail petition is not filed or likely to come before lordship most tomorrow, day after tomorrow, my lord.
Then we'll keep it for, we'll keep it. You have the case diary.
Lord.
You retain the case diary. They have filed an anticipatory bail petition. Let both of them come up together then. We'll not reject it today itself.
I leave it to lordship.
We'll have it on the 6th. You have it listed on the 6th. The case diary would be there. Let us see what can be done about it. But at this stage, with this kind of a recovery, list again on the 6th of March.
36. Obligement.
My lord, in this case, I was granted the anticipatory bail, interim protection, my lord. And thereafter, my lord, he's studying in Rajasthan. He came down, my lord, and appeared before the IO. Now his, my lord, statement has been recorded. And my lord, examinations are going on. The practical is, my lord, up to 13th, my lord, 13th March. My lord, my respectful submission is, my lord, further custodial detention may not be warranted. He will, my lord.
Yes, this man, they cannot be taking the money. Have they taken money from the accounts? No. They have said, give us money, we will invest.
Yes. In main accused, also have two other persons or two individuals, Muhammad Shakir and one is Rajdeep Dev. They are the main persons. And they recruit some agents to collect the money from the several persons.
He is one of the agents. One of the agents. Now,
Statement of the co-accused.
he did not point a gun.
Lordship.
He did not do anything. He said, you give me 10 rupees, I'll give you 100 rupees. This man gives 10 rupees. He should lose 100 rupees. His statement recorded anything, nothing. You make it absolute. Huh?
Yes, appear statement also recorded.
Absolute.
Okay, I'm going to the statement of the witness also. I have not found his name also. But only co-accused stated that he is the main person and he has stated that yes, he is one of the agent of him from where he collected the money from the several persons.
Heard Mr. S.K. Talukdar, learned counsel appearing for the petition. Also heard Mr. T.P. Goswami, learned additional public prosecutor. The petitioner has appeared before the investigating officer as required by the order dated 30/2/2026, and his statement has been recorded. The learned APP has submitted from the case diary that the further custodial interrogation of the petitioner may not be required at this stage. Full stop. In such circumstances, the interim bail granted to the petitioner by the order dated 30/2/2026 is hereby made absolute. Anticipatory bail petition is disposed of. And Mr. Talukdar, if you are using that mobile for if you are using it for the orders and all to assist you in the matters, you need a bigger screen.
Yes.
You lose. It'll trouble your eyes later on.
I'm obliged, my lord. In fact, the date is 03. It's not 30 mile. 0302 mile.
0302.
Yes. Perhaps your lordship has.
3rd of February. Interim bail granted by the order dated 3rd of February 2026. Na, paise? Is made absolute. Huh?
I'm deeply obliged.
Have a bigger screen.
I'll take the suggestion.
37.
Yes. 37. Criminal appeal. Union of India versus Urkula. Hmm. ইয়াততো এবাৰ মাতিছো কি Union of India busy. Huh?
Item 91, Lord, 39, Your Honor. Item proceed.
কি হৈছে মই বুজা নাই। Huh?
Sorry. What she made us.
We are at item 39 to হৈ গ'ল।
Lordship, in this matter, my lord, I'm appearing for respondent number 1, my lord, it's the order matter.
Huh.
Let it come up for admission, I would like to file a
Who is for the appellant?
for the appellant.
Okay. You will appear for Union of India. Item 39.
I'm for the respondent number 1, private respondent.
What were you saying?
I'd like to file written objection, my lord. 3 weeks time may be given, madam.
At the request of the
Fix your
learned PP. We are appearing for the respondent number?
respondent number 1, my lord.
Respondent number 1.
Respondent number 2.
Respondent number 1. List this matter again on. We'll have it on 23rd March
No, no,
or later.
Before that, because date is fixed on 26 March, I think.
So 23rd March is before that. 23rd of March?
Lordship, some time will be given because
24th of March?
26.
26th is the next date. I can only go up to 25th.
Yes, ma'am.
23rd of March?
Yes, 23rd of March.
23rd of March. Allowing the respondent, the first respondent to file their objections. Full stop. The learned counsel for the petitioner has made a submission that the matter is fixed on the 26th of March. Respondent number 1 to take notice of the same.
Any of them.
Yes. Anything urgent, madam?
Admission, ma'am.
Huh?
Come up for admission.
File your this thing, we'll see what is to be done. Huh?
Yes.
কি কৈছে আপুনি glance কৰিব নিদিয়ে আছে? Yes. What is this? Item 41.
My lord, I have one fixed matter at court number 2, lordship. Therefore, I am coming for mentioning. Very sorry for that. Item 41, lordship. I am directed to appear for respondent number 2, but appointment letter yet to issue by the Gauhati High Court Legal Services Committee, lordship. So next week, lordship. 41.
Any urgency for today?
No, not.
Or can we have it?
I have a prayer for small prayer to stay of the, because it is an argument stage, lordship, and trial court is pressing hard for.
No, when is the next date fixed? There must be a next date fixed.
7.
When is the next date fixed?
7th or 9th, lordship.
7th or 9th? We'll have it on the 5th.
Yes, lordship.
On 5th.
Okay, thank you.
Deeply obliged, deeply obliged.
At the request of Ms. R.B. Bora, learned counsel, who is under instructions to appear for the respondent number 2, list this matter again on the 5th of March. Mr. So-and-so escape with the learned counsel appearing for the petitioner is present. Huh?
Item 40, lordship. Lordship, in this matter, today we have filed Vocalat Nama, lordship. Item 40, lord, we'll file objection, lordship.
Who appears for the petitioner?
40, man, I'm appearing. One of the last date, if I may,
No, she's filing her Vakalatnama today.
Lordship.
We can have the matter on the 5th or the 6th if there is urgency.
tomorrow is the matter, my lord, fixed before the law.
Lordship, tomorrow we will not proceed here because tomorrow we have some exam duties, so lordship, here we will take adjournment, lordship. That
What
our
is the matter about?
It's about a questioning of an FIR, my lord.
Regarding
As section 225 of the BNSS has not been followed, my lord.
your good name, madam?
M. Das, lordship.
M. Das, learned counsel appears for the respondent number.
Respondent?
For the sole respondent. Mr. So-and-so is appearing for the appears for the petitioner. Ms. So-and-so has prayed for an accommodation to have her Vakalatnama on record.
Yes.
Full stop. List this matter again on the 6th of March. On the 5th of March, huh?
4 weeks, lordship.
4 weeks. Okay.
Because some documents we needed, lordship.
Okay. On the 19th of March. On the 19th of March 2026, the learned counsel appearing for the respondent has assured this court that the matter which is fixed tomorrow,
4 weeks, lordship.
which tomorrow cannot be attended by the
Complainant, lordship.
complainant since she would be on examination duty, and both the parties would make a request to the learned trial court to have the matter listed after the 19th of March,
Yes, lordship.
since the criminal petition is pending before this court. We are not granting any stay, but make a mention, have it listed after 19th.
Deeply obliged.
Island. Supplementary. Mr. Goswami, last order on 24th. On the 24th, we had appointed Miss D. Burman as the amicus curiae. There is no D. Burman.
She's not.
We'll have to appoint someone else. Matter is fixed on the 2nd of March. We'll appoint someone today so that he can give a copy and then we can proceed with the matter at least. On the last order, Ms. D. Burman had been appointed as an amicus to assist the matter. It has been pointed out that the learned counsel for the petitioner, upon inquiries, has not been able to trace up Ms. D. Burman, who is a registered amicus. No, who as a registered amicus, as a notified amicus, na? But is for the learned for the single bench. Accordingly, suggest a name. Huh? G. Sharma. Mr. G. Sharma is appointed as the amicus curiae. The learned counsel shall serve extra copies of the bail petition. Release the matter again on the 2nd of March. G. Sharma की detail से detail करते हो कुछ नहीं. 7 to हो जाना सिल नहीं. Union of India to NDPS. Very file कोई मिल जाए कोले. Oh. None had appeared for the petitioners. None had appeared for the appellants on 2206. None appears today also. Office note dated 24/2/2026 reflects that steps as required by the order dated 22/2026 have not been received by the registry. List this matter again on the 30th of March 2026. The continued absence and non-taking of steps by the appellants hearing may lead to an inference that the appellants are not serious in pursuing the appeal.
So the IA for modification of the judgment and order dated 10/2/2026. Then lordship, the treasury officer Bilashipara is to be written as treasury officer Dhubri lordship. Lordship, it is page 10 lordship, serial number 6 lordship. Establishment number treasury officer Bilashipara is to be written as treasury officer Dhubri. Then lordship, page 11.
No, you just tell us one thing. Who is the respondent number 6?
Respondent number 6 here in lordship.
Tell us. Treasury officer?
Bilashipara.
Why should we change it?
It is to be treasury officer Dhubri.
Why should we change it? Is it a typographical error?
It is lordship, it is for my purpose.
It is not a typographical error.
It is wrongly written lordship.
Ah?
It is wrongly written in the main petition lordship.
Oh. No, you've said in 3 and 4. Okay. This IA has been filed by the Do one thing. We'll take it up after some time. Have someone from the finance department to be present. Right? Because if the treasury officer has to be changed, I think the standing council should be put to notice. Have someone from the finance department here. We'll do it. But early, we don't have many matters left. Get someone from the. Yes.
42.
Last steps for service of notice was directly take up a respondent number. But we have taken my lord.
Taken the steps.
Yes, my lord. On case diary was called for.
Also, service report is awaited. Where is the FIR?
FIR, my lord, page 16.
16.
16. Type copy.
Charges frame, no. Charges not framed till now. The office note reveals that the case diary called for has not been received. And the report of service on the respondent number 2 is awaited. List again on the 30th of March, 2026. Petitioner, you have made any prayer for interim?
To stay
The petitioner would be at liberty to pay for the interim in the event the trial proceeds. Okay. If the trial proceeds, you make a prayer for interim.
49.
We have taken the steps on 11-2.
11-2. Then at least till 11-3 we have to wait. 4 weeks. And TCR has also not been received.
Not received.
And the learned counsel for the appellant has not collected the notice prepared for dusty service.
It has been. We will take it today, Lordship.
Learned counsel for the petitioner prays that may be given an opportunity to complete the steps. TCR has also not been received. Accordingly, list this matter again on the 30th of March.
Lordship.
Any interim is there?
No, Lordship. Much obliged.
এই রিটখন মাটি দিয়ক দুজন আহিছে ফাইনেন্সৰ আহিছে have you given her a copy?
Yes.
There was some mistake in the respondent number 6 when they filed the repetition. They are tendering apology and one that it should be substituted by the treasury officer to brief. Huh? Will allow it? The council heard Mr. Swenson and a council appearing for the petitioner also heard Mr. Swenson and a standing council appearing for this for on behalf of Mr. Pinak. Aliha. Standing council for the finance department, full stop. The prayer made in this petition in this I is that by an inadvertence in the cost title, the respondent number 6 had been described as the Treasury Officer Bilasipara, while the description should have been Treasury Officer Dhupri. Due to this inadvertent mistake during filing of the writ petition, in the order dated 10/2/2026, at paragraph
Paragraph 4, Lordship.
Paragraph
Second
4,
line, Lordship.
Second
line, Lordship.
Paragraph 4 and
10.
10. Paragraph 4, paragraph 10 and
cost title, Lordship. Respondent number.
no, cost title we are not changing. Paragraph 4 and paragraph 10. The directions have been issued to the Treasury Officer Bilasipara instead of to the Treasury Officer Dhupri. The learned counsel for the full stop. The learned counsel for the petitioner has submitted that the directions, if given to the Treasury Officer Dhupri in the aforesaid paragraphs, would not materially alter the intent of the order passed by this court. Full stop. We have heard both the counsels. And on going through the order dated 10/2/2026, this court is of the opinion that correcting that allowing the modification of the respondent number 6, allowing the directions to be made to the Treasury Officer Dhupri is not going to materially affect the intent of the order. Full stop. Therefore, it is provided that the directions given in paragraph number 4. No. We don't need to change it in the paragraph number 4. Yes. You made a representation to Bilasipara. We can't help it. Therefore, the directions at paragraph 10 to the Treasury Officer Bilasipara shall be now read to be directions made to the Treasury Officer Dhupri. Full stop. Accordingly, paragraph 10 of the order dated 10/2/2026 shall stand modified as follows. On receipt of the request for revised nomination, the respondent number 5 shall immediately process the same and after making necessary correction, forward it to the Treasury Officer Dhupri. Okay, who shall thereafter take necessary steps.
Lordship, then paragraph number 8 has to be changed, Lordship. On receipt of the aforesaid document, respondent number.
Paragraph number 6. Paragraph number 8. The paragraph number 8 shall be read as the on receipt of the aforesaid documents from the respondent number 8. Hetu correctly ase the Treasury Officer Dhupri. Shall forward both the halves. Any more?
And Lordship, paragraph number 7, Lordship, last line, the concerned Treasury Officer may be clarified. Treasury Officer.
No, that's a clear. You go and deposit it to Dhupri, they'll do the necessary part.
Lordship, already the petitioner approached.
They refused. No, because of the other part of the orders. Na? Now we have corrected the other part. It has been submitted by the learned counsel for the petitioner that the concerned Treasury Officer is the Treasury Officer Dhupri. I disposed of.
Master.
Now you have come 12 days later. Should we increase all the time by another 2 weeks for compliance? That is fair enough. Na? We should do it. Should we?
Master.
Made previous, Your Lordship. It's a complaint, passing of the complaint petition, Your Lordship. Complaint case has been registered under section 406, 420 and 506. Your Lordship, complaint case is in page number 12. The allegation in the complaint petition is that the petitioner, Your Lordship, has taken 8,50,000 from the complainant to give it to a landowner for purchase of a plot of land. And
No, the complainant had taken the loan.
No, Your Lordship, the petitioner who is seeking quashing of the complaint petition. The allegation in the complaint petition is that he has taken 8,50,000 from the complainant to give it to a owner of a land, the plot of land which the complainant seeks to purchase.
Okay.
But Your Lordship, in support of her claim that the petitioner has taken 8,50,000, there is in documentary evidence regarding that, neither there is any independent witness, Your Lordship. Lordship will kindly come to paragraph 5 of the complaint petition, page 14, Your Lordship. Page 14 of the complaint petition, paragraph 5. May I read, Your Lordship? That in the month of June 2018, a deed of sale agreement has executed between the complainant and said Subodh Chaudhary at Bongaigaon sub-register, and the purchaser has given her advance money of rupees 21 lakh only out of the total sale consideration in two parts. After receipt of the payment, the complainant came back to Gauhati, but after 2 days, the accused approached her and demanded a sum of 10 lakh only as his broker commission, but the complainant denied to pay such a huge commission amount, and accordingly an altercation took place between them, where the witness number 2 was present. The complainant had paid an amount of rupees 1 lakh only, and though the accused received the same, but he went back with anger. That the said purchaser had executed sale deed on 27/8/2018 before the sub-register Bongaigaon, after getting necessary permission from the office of the Deputy Commissioner Bongaigaon, white registered sale deed number so and so, but till today the purchaser has not cleared the sale amount, and as such the complainant had not handed over physical possession of the land to him. So, Lordship, this is in regard to another plot of land which the complainant complainant has sold, and admittedly the petitioner is a middleman in the sale process, and the complainant has taken 21 lakh as advance out of the 36 lakhs, and till now, as per my instruction, the property was not given possession to that person, and neither the complainant is willing to do the necessary sale agreement, Your Lordship. And regarding that, there are some altercation between the complainant.
That all understood. Tell us about this case.
Lordship, there is no documentary evidence, and neither there is any independent witness to substantiate the claim of the complainant, Your Lordship. And if in the case proceed, it will be a mere abuse of the process of law, Your Lordship. Moreover, Lordship, I have a judgment of the Honorable Apex Court in which it has said that section 406 and 420 cannot go together, Your Lordship.
So what do you want to proceed under? 406 or 420? Take a choice.
Not been framed, only someone has been issued.
The
Cognizance has been taken. Ours has
Lordship.
not been framed.
The cognizance
It will
order,
be framed later on.
Lordship, will kindly come to paragraph 20. 20. May I read, Your Lordship?
Yes.
On perusal of the allegation contained in the complaint, in light of the ingredients of section 406 IPC, read in the context of section 405 IPC, do not find that any offense of criminal breach of trust has been made out. It is tried law that every act of breach of trust may not result in a penal offense unless there is evidence of a manipulating act of fraudulent misappropriation of property entrusted to him. In the case of criminal breach of trust, if a person comes into possession of, if the person comes to the, in the case of criminal breach, if a person come into possession of the property and receive it legally, but illegally retains it or converts it to its own use against the terms of contract, then the question whether such retention is with dishonest intention or not, and whether such retention involves criminal breach of trust, or only a civil liability would depend upon the facts and circumstances of the case. In the present case, the complainant respondent number 2.
Read. Para 21, we have read.
Lordship.
Hmm.
Lordship, in this case also, the entrustment of property is not shown. In order to attract 406, the ingredients of section 405.
Charges are not yet framed.
Lordship.
Is it not?
Lordship.
When the charges are not framed, let us not go into the probable charges that may be framed.
Lordship.
Tell us why cognizance is wrong. Someone comes to the court
Lordship.
and says, look, this man has taken my this amount of money.
Lordship.
You want this court to say that no, the trial court should not even look into it. Why?
Lordship. But your Lordship, there is no evidence, only to harass the petitioner because.
Evidence would be seen by the trial court.
Lordship.
And that is why the first thing in evidence has been done. On oath, the complainant has been examined.
Lordship.
If she has lied on oath,
Lordship.
you are there to prove it for them. That okay, this is a lie on oath. Parjuri hai, ye hai. Lot of things coming.
Lordship.
But the court should not even look into complaints. You have to convince us on that for us to interfere. You may have a good case for discharge. Do you have a good case for quashing? The moment we start interfering with the trial court orders in this manner, trial court should be very wary of taking on complaints. Tomorrow your client may be cheated or his property may be misappropriated. Someone else will come with this order saying that it should be not entertained. Is it not? Not only one order, but we have to see into the consequences.
Okay.
Tell us why the trial court should not even hear you or call you to be heard.
Lordship,
If it doesn't call you and frames the charges, you will say principles of natural justice. I am not even given a summon.
Lordship, only on the basis of the statement can.
That is what the law requires. Only on the basis of the statement.
Lordship, but
Cognizance will be taken.
Lordship,
What is cognizance?
but while taking cognizance, your Lordship, materials on record has also to be seen, your Lordship. No materials has been, no documents regarding a person giving 8,50,000 to an unknown person without any token, without any document, and no independent witness to support her allegation, to support her statement. Can a trial proceed, your Lordship?
Yes.
My lord, in this case, not only the complainant, but the learned trial could have also examined another witness, my lord.
Whom?
Yeah, is one of the witness, my lord. My learned friend had to annex only one witness annex, my lord. It will be in the record, my lord.
Yeah.
And thereafter has taken the cognizance, my lord. In impugn order itself, my lord. It is mentioned, my lord.
Yes, madam, you say there is no witness. There is some witness, some evidence.
The interested witness, your Lordship.
Oh, that is what you will prove in the trial.
Mother and.
And my lord,
Her
complaint
mother
is,
only.
my lord, thereafter evidence before charge, and there also a stage of framing of charge. My learned friend can, my lord.
Then why a complaint case, your Lordship? There could have been a FIR. There could have been a money suit also, your
So
Lordship.
that's why complainant, my lord, itself
Why complaint
examined,
case?
thereafter one witness also examined.
How interested witness, your Lordship?
Maybe, my
No FIR regarding this money.
That is a matter of, madam, if we take every mother to be an interested witness, no mother will be able to give a
No,
testimony before the court that yes, my son was murdered. Interested witness.
that is.
My daughter was forcefully taken away. Interested witness. Can it be?
Lordship is.
The circumstances will say whether interested witness or not. Mother is also gave 6 lakhs allegedly. Then interested witness. Yes, both persons coming together.
Lordship is correct, your Lordship, but no FIR. If 8,50,000 is involved, then they can go for money suit also, your Lordship. Why a complaint case?
You argue on that line that money was given but not utilized for the purpose. Then again, criminal breach of trust.
No, how No entrustment, criminal for criminal breach of trust, there should be entrustment, your lordship.
Ah, the 8 lakh 5, that is our allegation.
Lordship.
That is why the trial court will see the correctness of the allegation. Are we supposed to see that and comment on it? Can we? Then we will have your witness, we will have their witness, small box there, keep on cross-examining. Can we do that?
Then only why a complaint case, your lordship? No FIR regarding that. They could have given a FIR.
That is your argument before the trial court. Why before me? You have to appear and you have to tell the trial court everything.
Okay.
Then the trial court makes a mistake. And you come rushing to us, no problem. But okay, someone has given on oath, 8,50,000 was given, not returned, used for other purposes, cheated, maybe criminal misappropriation, maybe cheating. Something has happened. Okay, let us hear you. That is what the trial court has done. Okay, we'll hear you.
Lordship will kindly see that in the complaint petition itself, the complainant has alleged that there is an altercation between both the person, and the person with whom altercation has occurred, subsequently she has given 8,50,000.
Matter of trial and argument. Again,
It will be an abuse of the process of the law, your lordship. Because it is a subsequent event, your lordship. It is in the complaint petition itself, your lordship, paragraph 6. Lordship will kindly see. Paragraph 5 also, your lordship, there was some altercation between the complainant and the petitioner. Paragraph 5 also.
It's a case for causing made out, Mr. Goswami. Neutral party. You are the neutral party. We will be burdening your court if we do not allow this. If we allow this, your court will have one case less. We will also have one case less in either of the two.
Probably taken and charge not framed here.
Charge not framed. They can go and argue whatever they want to.
And not only my complainant, but another witness. It is from the cognizance order itself, on prima facie case matter.
If they have
And in the
admitted,
complaint matter, it is categorically stated matter. On the face of the complaint matter, there is offense.
the complaint petition itself reveals that both the complainant and the petitioner were not in good terms. In spite of that, she has given 8,50,000 to him without any document, without any token. That is my case, your lordship. She has admitted in her complaint petition that there was no good terms. He used to pressurize. There's altercation between the petitioner and her. In spite of that, subsequently she has given 8,50,000 without taking any token, your lordship. And no independent witness also to substantiate her claim.
May I place one judgment? This is in relation to quashing, lordship. What are the state? Lordship, I think the copy, lordship. This is lordship special leave petition.
We are handicapped. Yes, tell us. Citation to Lokson.
Special leave petition criminal.
SLP criminal.
Number 11642. 2019. It is Pradeep Kumar Kesarwani versus State of Uttar Pradesh.
What does it say?
Very recent one.
What does it say in few words?
The following steps should ordinarily determine the veracity of a prayer for quashing raised by an accused by invoking the power vested in the High Court under 480. Number 1. Step 1. Whether the material relied upon by the accused is sound, reasonable, and indubitable, that is, the material is of sterling and impeccable quality.
There is no material before us.
They have to show.
Now, from the accused, there is no, in the present case, no material from the accused, so one is gone.
Yes.
Then?
Number 2, step 2.
But it is in the negative, you see. She is saying, I did not take the money. What kind of a material she will produce to that I have not taken money? You can't give negative proof. So that one is not applicable in the case.
Number step 2, whether the material relied upon the lordship, they must be relying on something lordship to show.
No.
This is the process.
That will be in a case where he says that she attacked me. And she says, I was in Delhi. So she'll produce a flight ticket, she'll
Yes.
produce a hotel receipt.
Yes.
Here is a case, she's saying, I did not take the money.
Yes.
So she cannot show any proof that I did not take it.
Yes,
Proof of the negative cannot be given.
correct.
So that one goes.
Yes.
She's simply saying, he never gave me money.
In that case, lordship, may I just submit lordship?
Ah.
In that case, lordship, that stage has not yet come.
Exactly.
Because lordship, the charges are yet to be framed.
Yet to be framed.
The court has not taken a prima facie view, lordship. And at this stage, lordship, if I may just point out, lordship, and lordship will be knowing, lordship, the court is not supposed, I mean, the High Court is not supposed to take a view of conviction or
Nothing.
acquittal.
Nothing.
Only prima facie, lordship.
Prima facie, one person comes crying to the court. I paid 8.5 lakhs,
Yes.
not returned to me, not utilized in the manner it was supposed to be utilized.
Yes,
So at this stage, even we cannot think whether it was
cannot.
from the initial stage a mentality of cheating,
Yes,
or after being handed over the money,
yes,
then the
yes,
malafide comes in.
yes,
So it can be 420, it can be 406. We do not know.
yes,
That is what the trial court would look into.
yes.
Frame charges accordingly.
That
Yes, madam.
stage, lordship, the discharge is also there.
There can be also a discharge and there is no evidence. Go home.
This prayer can be
Sorry,
made-
sorry.
So my
It will also
complaint,
happen.
Lordship, because complaint petition itself reveals that both do not share a very good relation, cordial relation. There are altercation between both of them.
We will also provide that in case you make an application, Assam police will give you a bulletproof jacket, no problem. See, keeping a case hanging like this on a stay, when the only issue is whether cognizance was correctly taken. The court is required to see into two things. One, the complainant has to be examined and some material has to be produced. That material is produced in the form of the statement on oath of a witness. Court thinks that yes, we should hear what is happening. Go to the court and say all these things. The court will say that we do not have enough material to frame a charge. So you are discharged.
Lordship, then at this stage, I may be allowed to withdraw with liberty. Your Lord.
Liberty to do what?
To come again if surge is framed, Your Lordship.
That option will always be there at the appropriate stage. We will not go and tell the court.
Okay.
Show to the court that this is what is before. Cross-examine them. No document, no nothing.
But it will be.
Stage will come.
Okay, but when the complaint itself has been filed with a malafide intention, then it will be a clear abuse, Your Lordship. There are no good relation. It is in fact stated in the complaint itself, Your Lordship.
Criminal complaints are rarely filed when there are good relations.
But giving
Rarely. Huh?
8,50,000
Even that will be a case of cheating then. That he said he has a good relation, but he's filing criminal complaint.
without having good relation, Your Lordship.
Huh? Huh?
Without having good relation, having so much faith, giving.
Why did you give that 8.5 lakhs?
I have stated in my complaint.
Cash.
There is a.
Cash.
Yes, madam.
You give cash 8.5 lakhs.
Lordship.
2022.
This is how this.
That is after this notebandi. Where did you have this 8.5? Huh?
Madam, the money received has not been given. It is written.
First
but
tell us,
the-
where did you get 8.5 lakhs? Where did you get it?
Madam,
Give
This is mentioned.
cash. People were
madam,
looking for
there are
500
eight
rupees cash and you are saying 8.5 lakhs cash. Cash, have you said cash?
Otherwise, they would.
Have you said cash?
Madam, no.
Bank.
Not madam.
ATM.
Its money received has not been given, my lord. Para 8, my lord. That suddenly accused on 23/9/2018 from the complainant that the owner of the her selected land informed him that if no amount paid to him as a token money, he will not wait for the same to other intending customer.
Huh.
At that time, the complainant was very busy with her service as already she had taken so much leave. So, having no grant of leave, she is unable to go to Bangaigaon for payment. Then the accused told her that he may come and take the money from to pay the landowner and will bring the money to token money received. And having no option, the complainant
Yes,
accordingly
heard
on
means you want to withdraw with liberty to come back at the appropriate stage.
and
Because
8.5 lakhs. Cash you have given, you will have a very
but it is
difficult time.
in the 2018.
You will have a very difficult time in the
Whatever
trial
my-
court, even to have charges framed. After some hearing in the matter, Ms. Swensel and a counsel for the petitioner has prayed that she may be allowed to withdraw the matter at this stage with the liberty to approach again at the appropriate stage if a grievance remains. Accordingly, this criminal petition is closed on withdrawal, allowing the liberty to the petitioner to approach again at the appropriate stage in case a grievance remains.
Not earlier stay order may be vacated.
Interim orders passed earlier stand merged with the final order.
Oblige your lordship.
A criminal. What was it?
If the petitioner was convicted for 5 years of sentence under section.
From 2023, the bail has not been granted. Why don't we take up the appeal, sir?
So right now.
Let us
I'm
take up the
placing-
appeal and finish it. What was the appeal?
We can be taken up with the short issue.
Tell us. We'll take up the appeal. We'll close the chapter. Boli.
Lordship,
It all of solai diyosun. Dorok khwa karone gorom uchche neki.
judgment at page 46, Lordship of I report.
Page
46
of the appeal.
of the appeal.
Of the appeal. Anyway.
Equity Akash Lewis is convicted under section 10 of the PROCEEDINGS Act and sentenced to undergo rigorous imprisonment for a period of 5 years. And also to find a fine of
Judgment like ekelage
5,000 in default to undergo rigorous imprisonment for a period of 3 months. Equity is also convicted. Equity is also convicted under section 354 IPC.
So tell us what is wrong with the judgment.
Contradiction of 164 statement and the deposition of the PW1. So there's improvement in and contradiction. In 164, that the victim said that she was alone at home during that time, and in examination in chief, she stated that she was in her house along with her elder brother, Bhavesh Gwala. Bhavesh Gwala was not examined. That's what.
Yes, what is your ground? Kindly tell us your ground.
Then I have to mark the lower court record, let me find the 164 statement. Their primary ground is that there is a discrimination between the 164 and the evidence which she has adduced. She is Lordship PW1.
PW1.
So Lordship will kindly go to the 164, then the PW1. If there is material contradiction. My learned friend is proficient in some inspection. He's proficient in Assamese Lordship if necessary.
Ah. Yes, sir. Mr. Goswami, you are proficiency in the language.
He can read out.
But do you have the, or he has to read it out from there?
164 Lordship, I don't have a copy. They have not next it probably, I'm not sure. Next question. Yeah, 164.
What is the inconsistency?
Improvement.
Huh?
They have used the word improvement. Let's see, improve.
I do not find much improvement there.
In 164, she stated that I was alone at home.
Hmm?
In 164,
Hmm.
he said that I was alone at home during that time.
Hmm.
But in the examination of chief, he stated I was in my house along with my elder brother Bhavesh Gwala. Bhavesh Gwala was not examined.
At that time, our neighborhood sister called my brother Bhavesh to her house. At the time of incident, not prior to or after. We need at the time of incident, she was alone, she was alone. Bhavesh would not have kept silent. Either he would have participated or he would have defended, either of the two.
In 164, she stated.
Being the, huh?
In 164, she stated, সেই সময়ত ঘৰত মই অকলে আছিলো আৰু মোৰ লগত কোনো নাছিল। In her
she has stated that my brother Bhavesh was there, but he was called away by the neighbor.
I was in my house.
And therefore he went away.
Bhavesh Gwala.
And when the man came, I was alone.
Yes.
Now we start from when I was alone in the house again.
I was in my house along with my elder brother Bhavesh Gwala.
Yes.
That's lordship. In 164, she said, সেই সময়ত ঘৰত মই অকলে আছিলো আৰু মোৰ লগত কোনো নাছিল। In examination sheet, I know Kush Gumis and he is my relative. The incident took place on Wednesday. I was in my house along with my elder brother Bhavesh Gwala. That's the difference, lordship. Then lordship, come to the cross examination of PW1, the first paragraph, last line. Cross examination of PW1, the very first paragraph, last line of the first. I had a love relation with Tatu Gwala.
With
Tatu Gwala, but thereafter we broke up.
Which page?
Cross part, lordship.
Cross up? Which part?
Cross examination of the.
I had a love relation with Tatu Gwala. Tatu Gwala did not do it. Tatu did it. Tatu is the accused.
No, Tatu is not. It's another person. So? I had a love relation with Tatu Gwala, but thereafter we broke. This statement, this cross examination, be read with the suggestion put forward to PW4 lordship. PW4
all along, Lordship, supporting the version of the accused. Lordship, kindly have a look at.
Age is proved. Age below 18 is proved.
Age below 18.
Now, reverse burden, or what do they say? Proof, you have to prove your innocence, sir. In a POCSO act, you have to prove innocence. No one has to prove your guilt.
Lordship. Kindly, Lordship. PW4.
Eh? PW4.
Other ground. May I decide? I know the informant Rekha Gwala as resident of same garden. I know her daughter so and so, is the victim daughter. I also know the accused Akash Humus. I heard about the case lost by Rekha Gwala in June so and so.
When were you arrested? After how many days of the incident?
Just next day. The affair was lost on 5/6/22 and I was arrested on 6/6/2022. Akash Humis himself told me that on the date of incident, he went to the house of Rekha Gwala to search his mobile phone and asked a glass of water from Nitimuni Gwala. And there, when Nitimuni Gwala offered the glass to Akash, Akash was looking at his mobile and mistakenly caught the hand of Nitimuni instead of the glass. Then Lordship, close of the PW4. As Akash was looking at his mobile downwards, mistakenly he caught the hand of Nitimuni, thinking it to be the glass of water.
And that mistake was that mistakenly holding the hand. Somehow it went out to pulling also, then pushing also, then groping also, roaming also. How can everything happen mistakenly when you are looking at a mobile?
Nitimuni earlier eloped with another boy when Akash helped in tracing them out. Last line.
Paragraph 28.
Close of PW4 Lordship. Last line.
Rekha also wants Nitumani earlier eloped with another boy Akash. Help in tracing them out, and because of which there is a dispute between them since before. Yes.
Because
Akash was previously interested. He wanted this. What is his name? Gutu or what? That person to vanish. Once he vanished, the victim is alone, unguarded. Our minds are running in different ways now. We should not be doing that. Huh?
PW4 all along supporting the version of the accused Lordship, but
saying what? That there is a enmity between the victim and the accused. So therefore now party POCSO Act, you have to show that the accused did not bear any enmity to the victim. The burden of proof is on you.
PW4 was not declared by the trial court as a hostile witness.
Well, let it not be. Let it not be. POCSO, once the allegation is there, if I'm not wrong, the guilt is presumed. Like in this bribery case, the guilt is presumed. Now you have to prove that no, this is a false case. I was not there. The lady did not suffer.
So for charging under section 10, it should have been the section 8 Lordship. As a whole. Instead of convicting the petitioner under section 10 of POCSO, should have been under section 8 Lordship.
Section 10?
10.
Why section 10? So POCSO concept.
For that, Lordship, on PW, I will just point out one thing, because it will then skip my mind. Whatever PW4 has stated, Lordship, will see the evidence, because in that evidence he has stated what he was told by the accused. It's not an eyewitness, Lordship. It is his hearsay evidence. What the PW4 is stating here, Lordship, is what the accused told him.
Huh.
That he was only charging his mobile. He is not eyewitness.
He is charging his mobile, he is looking at his mobile,
Yes.
and when the glass of water came, instead of the glass, he caught the hand.
Yes, that was told.
What
by-
about the rest of it?
Yes. So Lordship, that
It
does
cannot
not-
happen while looking at the mobile.
He is not supporting the case of the.
He's not. Only to the extent that the accused tries to say that, look, because there was an enmity, because I had got you caught,
Yes.
you are trying to frame me. And he says that, yes, it is true, she had run away.
Yes.
And he had been instrumental in
Yes.
recovering. 33. POCSO. In any prosecution which requires a culpable mental state on the part of the accused, the special court shall presume
He is alleging that fact, Lordship, so burden is on.
it is on him.
And may I just point out PW3 as well, Lordship.
Aggravated. What is aggravated? Where is aggravated given?
It's
Not penetrative, aggravated.
it's
9. 10 is what? Huh? 10 is aggravated. You said 10.
10 is aggravated.
10 what?
Right. Punish.
Why 10?
assault part is there,
Which assault part?
sexual assault.
No, they say aggravated.
Aggravated.
Section 7 would come in if it is only a sexual assault. 8 would come in with punishment with sexual assault. How do you bring in aggravated here, sir? Why aggravated? He's saying 10. 10 is aggravated. Where is that aggravation part?
Aggravated section 9, roughly.
Eh?
Section 9.
Go from the judgment, tell us this is why he has taken it to be aggravated. Oh, para 55 of the judgment.
Yes.
Relative.
Yes. Yes.
Anything else?
No, no, sir.
Eh?
No, PW3,
PW3, yes.
because I pointed out PW4 Lordship.
Huh?
PW4, he himself stated that I was present at the place of occurrence. What the PW3 has stated, Lordship? page, PW 23. Lordship has found it?
Hmm.
Yes. Incident took place at the house of Rekha Gwala, which was adjacent to a house. That it was at 6:45 PM that she was preparing food. At the time, X came running to her house. She was crying, and on the rocks, she told crying that Akash had asked for a glass of water. Then when she gave that glass, Akash got over fever on the so and so. Deposed in court that she then came to their house but did not see anyone. That there was no household members in the house of Lokpagul.
There was no.
There was no members in the house of Rekha Gwala at that time.
Hmm.
So it corroborates what the victim is stating, and also Lordship, the fact that he ran away from there, Lordship. He confirmed his presence before PW4 that he was there, but after the incident, he left the house. So that is supporting Lordship. Lordship, may I show any judgment regarding they have raised the ground of contradiction. The contradiction has to be
Material.
and it should go to the
Root of the issue.
Now here, yes, they are.
Whether prior to the incident there were people on the house or not is not going to the root of the problem.
May submit before your Lordship some citations.
Your Lordship, regarding discrepancies in evidence, I have a judgment, Lordship. May I read out, Lordship? It is
You do one thing, you give us the copies.
copies,
You give us the printouts or the citations or whatever.
Lordship.
Huh? We are not finding much in the appeal as of now. If going through the judgments that you cite, we need to change our mind.
Okay, Lordship.
We will have it listed for to be spoken to. And if it does not change our mind, our today's order is heard Mr. So-and-so learned counsel appearing for the appellant. If Mr. B. Sharma learned APP. And yes, you are appearing for?
Respondent number 2.
Respondent number 2. What do you say? He's not guilty. He does not appear to be guilty.
Well, in such cases, my lord, the sole testimony, my lord, is my lord, sufficient for my lord convicted the my lord accused person. My lord.
Sole testimony if
Sufficient.
not contradicted.
Not corroborated any required, no corroboration is required, my lord, in such of cases, my lord. And my lord, minor discrepancy in testimony, my lord, for cross examination is not sufficient to totally discredit the witnesses, my lord. And I have a citation, my lord, of regarding.
All the citations you give. You give the citations. Mr. So-and-so for the respondent.
Reasonable order, my lord, may not be interfered, my lord.
Oh, you are saying that the trial court order is reasonable. I thought you were asking for a reasonable order. Arguments concluded. For judgment on Monday. For delivery of judgment on Monday.
Then I will submit my citation.
By tomorrow latest.
Tomorrow, Lordship.
By tomorrow latest, give the copies. Saturday, Sunday, we want to utilize.
I'll give it on Monday, Lordship, then Tuesday.
Tuesday is closed, Thursday, Wednesday is closed. Man is behind bars, he should be sure whether he wants to remain behind bars or he goes home. Only judgments you want to give. Give it now.
Okay, Lordship.
No, it has judgment. Kali তাতে লিখি দেবো appellant. Judgment to উপর appellant লিখে দেবো. Delivery of order Monday. Judgment of order labor can deliver in Monday. Gary lose. That is something.
Lordship.
Yes.
Lordship, in this case, Lordship, both the honorable court below, Lordship, against my favor, Lordship, so Lordship, before your Lordship.
It happens sometimes, eh? Yes.
Yeah, Lordship, before going through the order, Lordship, may I come to at page lordship 11 lordship, the complaint petition lordship, because it is the root of the entire case lordship. It may be Paris lordship.
Do we have the time to read the whole? There was a check, went for collection, not honored.
Yes, lordship.
Where is the fault?
Already lordship, alia lordship, the accused lordship lodged a GD&T lordship.
Hmm.
Taking plea that lordship, the check was lost lordship.
Hmm.
From where he was visited from Hailakandi to his native place lordship.
Hmm. Then he found it.
No lordship.
Then without finding, how did he lodge it?
He lodged lordship for missing this check lordship.
Then?
Pocket lordship. Thereafter lordship, the complainant lordship filed a case against me lordship, complaint filed lordship.
Hmm.
And the matter is started lordship.
Hmm.
Here lordship, first of all lordship, may I go through the complaint petition lordship at page 12 lordship.
Then did you pursue it? Did you take this ground in the trial court? That I had lost the check.
Yes lordship.
It was taken. How was it dealt with?
Lordship, it was lodged lordship before the Algapur PS lordship, the GD&T was made lordship, first of all lordship, and thereafter lordship.
Where you are a resident of where?
I'm resident of lordship, I'm resident of Kachar district lordship.
And you are going to Algapur. Why?
Village lordship, from Hailakandi lordship.
From Hailakandi.
Yes lordship, when I was visited, I was coming from Hailakandi.
You lost it in the Hailakandi. You gave a GD entry that I have lost a check.
Yes lordship, it's first of all lordship.
When?
And thereafter lordship, he made a complaint also lordship before the Katigora police station lordship, thereafter lordship. And which was also registered as GR case before the Kachar judicial magistrate lordship.
Just a minute.
Complaint is at page 12.
Where does the lower court, where does the additional CGM they deal with this issue about the loss of check?
About the loss of check lordship, the Koringan court lordship did not provide any opportunity to collect the all materials lordship. The police, though lordship submitted the petition lordship. The investigation was not sufficiently taken lordship. Investigation was not sufficiently taken by the police lordship.
Regarding the loss of your check?
Yes lordship.
There was one check in your checkbook
Yes lordship.
which walked out of the checkbook and got lost.
Not one check lordship.
How many checks were lost?
Lordship, for some check lordship have been lost from his pocket.
Contain the loss of numbers of check from Iman to Iman. Yes.
Lordship, the complaint petition lordship filed it by the complainant lordship.
There must be a reply to the notice given by the.
No lordship, notice was not served lordship. This is the question. Lordship. Notice was not served lordship upon me lordship. Lordship, only there is
not only your check, you are also vanishing.
No lordship, notice was not served because lordship, the complainant village is lordship at Korimganj lordship, and I am from Kachar lordship. The notice served by when lordship, and in his lordship endorsement lordship, he reflected their lordship. The owner is not found lordship. It is lordship at page in the record.
Was that the address given
lordship,
in your business cards?
it is lordship at page. Kindly see the record lordship. Record part lordship. If we go to lordship, the record part lordship. Malik বাড়িতে না থাকায় কোনো জারি হয় নাই.
The issue is not that. The issue is that when you issue a check, when a person takes a check, you had some business relationship.
No, lordship.
No business relationship.
It was also not proved lordship. This is the case lordship. And lordship not he paid me 6 lakhs lordship, according to their claim lordship. But not a single slip or anything lordship he was proved lordship. Even lordship not a single witness lordship in favor of payment lordship. So lordship, in the claim petition lordship, he said that lordship one middleman, but there is no name is mentioned lordship in this complaint petition lordship, and no date was mentioned even lordship when he paid me lordship. And subsequently it was developed lordship in the gross part lordship.
Yes, how do you use a lost check?
And lordship,
Why did you use a lost check?
That is the
person?
veracity. My friend has not cleared that point, Lordship. I am clearing on that point,
Hmm.
Lordship. My lord, the loan was taken in the year 2010. He failed to repay the loan.
Hmm.
Thereafter, Lordship, on 15 to 2011,
Hmm.
check was issued.
Hmm.
And that check was dishonored on 24 to 2011. My lord, these dates are very important because
15, 11 and 24 too. Then
24 to 2011.
Hmm.
Thereafter, this lordship notice was issued. After notice is issued, but could not be served because the address is not found on that. My lord, he take the defense point that 25 leaf of check, 25 number of leaf of check was lost on 19/11/2010.
but he already signed it on 15, 11.
Yes, 15 to 2011. Check was issued.
1911 already
Now
3
he is
months
saying
ago.
that 19/11/2010, 25 numbers of leave of check was lost. He informed the bank on 28 to 2011. He lost on 19, but informed the bank on 28 to after 10 days about. And a police case was he filed on 1/3/2011.
He said there is a GD entry prior to that.
GDNT lordship, it is first lordship, first of all, lordship 19/11/2010 lordship. GDNT was made lordship.
And that case has dismissed. Lordship, he wanted to club this case with the CR case, and he filed a petition. That was rejected on 15/6/2000. Club together rejected on lordship 15/6/2024. Against that, no appeal, no revision has been filed. So now he is taking that he wanted to club that case, his case with this case, but that prayer was rejected. And so far revisional power is concerned, your lordship, this is very important because the ground on which a revision petition can be, your lordship can exercise the power. In the revision petition, there is no such pleading. And in the my submission of my friend is also silent on that point. What is the perversity? And what was the material that was not looked into the
That is what you're asking.
lordship, to that effect, lordship, I am raising that judgment, lordship. Because after the trial court order, he filed an appeal. Appeal dismissed. Now this is a revision, lordship. Just one paragraph, lordship 8. Lordship,
8.
8.
Ah.
Before examining the merit of the present case, we must advert to discussion as to the ambit and scope of the power which the court, including High Court, can exercise under Section 397 and Section 482 of the Code. Section 397 of the Code vests the powers a court with the power to call for and examine the record of an inferior court for the purposes of satisfying itself as to the legality and regularity of the proceeding or order made in the case. The object of this provision is to set right a patent defect or an error of jurisdiction or law. There has to be well-founded error, and it may not be appropriate for the court to scrutinize the orders which upon the face of it bears a token of careful consideration and appear to be in accordance with law. If one looks into the various judgment of this court, it emerges that the revisional jurisdiction can be invoked where the decision under challenge are grossly erroneous. There is no compliance with the provision of law, and finding
recorded is based on no evidence. Material evidence is ignored or judicial discretion is exercised arbitrarily or perversely. These are not exhaustive classes but are merely indicative. Each case would have to be determined on its own merits. My lord, none of these grounds.
Why did you send that to a wrong address? That letter, why did you send it to a wrong address?
No. My lord, no, there is no pleading to that effect that address was wrong.
Address was correct, Lordship.
So,
But Lordship, I had no knowledge, Lordship, over the notice, Lordship, because the record itself proved that, Lordship.
That it could not be served because you were not
On the
there.
same date, Lordship.
Hmm?
There was no due diligence to serve the notice, Lordship.
my lord, the Honorable Supreme Court in a judgment held that instead of disputing on the notice whether it is served or not, after getting the notice of complaint case,
Did
he
you
should
try?
he should have paid the entire amount and go to and appear before the court. Yes, I have got this notice of this court and I paid this amount. The matter should be closed. Lordship, to that effect, Lordship, I am relying another judgment.
This fact is different, Lordship, because I already made a GD entry, Lordship, regarding this, Lordship. I lost of my check, Lordship.
Para 14, 15, 16 and 17. 17 is very important. In fact, all this
Total amount of check
6 lakhs,
6 lakh, Lordship.
from 2011,
2010.
10. Yes, so that's why we should interfere in the revisional part. Huh?
My lord,
This is a revision, is it not?
Or there is, Lordship, evidence in not, Lordship, properly taken by the lower court below, Lordship, and error.
paragraph
in the
17,
Lordship
Lordship,
order,
it is actually paragraph
The Honorable
14,
Court had power,
16 and 17, all are relevant. 17 is very important.
because, Lordship, first of all, Lordship, more than 20,000, Lordship.
The trial
cannot-
courts, the trial court and the appellate court have found that GD entry is not a correct entry, is it not?
Yes, Lordship, it is, Lordship, it is
Once they
doubted, Lordship, doubted by the court, Lordship, doubted, Lordship, the Honorable Court, the court below, Lordship.
Doubted?
Doubt, Lordship, doubt.
Doubted, huh? So now once two courts doubt it,
Yes, Lordship.
in revision we should appreciate
Merely
it. It will
presumption
be,
and assumption, Lordship, the order was passed, Lordship.
Huh?
Presumption and assumptions, Lordship. Order was passed, Lordship. Because, Lordship,
the
more than-
checks which are
more than
lost in
20,000,
19,
Lordship.
the checks which are lost in 1911 of 2010 and which are put before the bank in February 2011
Yes.
or maybe 2020. November they are lost. February that check is put before the bank. Check is bounced. Then you tell the bank, please don't honor the checks. They are lost check. Is it not? That is what we have understood from the dates.
Yes.
19, 15, 24, 28, something like that.
Yes, Lordship.
And another important veracity is that he has informed the bank that 25 leaves were lost. But in his evidence, he has stated that only 7. Only 7.
It is possible, Lordship. I
And
will
secondly,
submit in favor of my
secondly,
Lordship.
regarding this 25 check, the trial court as well as the high court has given the schedule that he has withdrawn the money with this sum of these checks.
At the time,
And in
Lordship,
the appellate order, your lordship will get the sum. Yes.
when someone may not memorize, Lordship.
There is a limit to what you can do.
Page 50, your lordship will get.
In the law part, Lordship, he cannot pay, Lordship, more than 20,000, Lordship, in cash, Lordship. More than 20,000, Lordship, cannot pay, Lordship,
To whom?
in cash, Lordship.
To whom?
To someone, Lordship, anybody, Lordship, to anybody, Lordship. Because, Lordship, it is the judgment, Lordship.
Should
in
we give
Kerala-
examples?
In Kerala High Court, Lordship.
Huh?
In Kerala High Court, Lordship, there is a judgment, Lordship.
In Kerala, you cannot give more than 20,000.
Lordship, it is Lordship discussed about the judgment of Supreme Court
Our
also.
experience is that you cannot
Evading income tax, Lordship.
declare and give more than 20,000 in cash.
Evading the income tax, Lordship. Because-
Undeclared, any
Lordship,
amount can
first
be
of all, Lordship, debt must be legally enforceable debt, Lordship. It is a provision, Lordship. And it was not proved by the complainant side, Lordship.
Page 50, lordship.
Even not a single witness and not a copy of lordship slip.
You are withdrawing all the money by self-checks which are lost
Yes.
in the year, in November 2010. And did you tell the bank that, sorry, these are not the checks lost, these I have, these I have?
Lordship, though lordship PW was proved lordship, PW was a bank.
Wrong
official.
advice, that lodging of that
May
GDFT
submit
and
the
all is
judgment,
wrong advice.
Some of the judgment I also have lordship.
Oh, yes. Show us.
Judgment.
You are not showing. We are eager to learn.
Admittedly, lordship, he has not disputed the signature of the check.
Yes, lordship.
That is, so
Not
presumption is there.
No, he signed it and he kept it with himself. And then they got lost.
That
And
is-
he keeps signed
Yes, he
checks.
has signed all this paper.
Ha,
all
and he
the-
has kept with them, with himself.
Yes,
And when he has gone from Karimganj to which place?
From Hailakandi to lordship.
Karimganj, then they get lost. Huh?
From Hailakandi to towards lordship
and
here.
in fact, this.
So why was it checked? So why was this check signed when it was lost?
It was lordship, the date was not
The
mentioned. here.
signature on the check is yours.
Yes, lordship.
The check was lost.
Yes, lordship.
It was not issued to anybody, at least not to this man.
Lordship.
Is it not? So you keep signed checks.
Your lordship will see,
This is off the record. I can ask for the visuals to go, but we heard it in long time ago in cinema halls. Blank check did here. Your client seems to be carrying 25, 26 blank checks. These are made up stories.
your lordship will see. I am
What is the
only
revision
lucky
part? Tell
person.
us.
I am the only lucky person. He has lost 25 leave, but I am the lucky person.
Yes,
I
tell
got.
us. Why the revision?
Lordship,
Revisionary power. Why we should exercise? Just tell us that we are listening. If we have the power
go through the evidence part and lordship, on the.
to go through evidence,
Lordship.
I will go through the evidence in revision
This is the error of the lordship on the land court below lordship.
that he misappreciated the evidence.
Lordship. Because lordship,
Okay. And now appellate court has done it. Appellate court has also gone through it.
lordship.
Then
Lordship
now can
also
I go
should
in?
not touch the evidence lordship because debt must be legally enforceable debt lordship. So it is a one of the lordship statutory provision lordship. And lordship notice must be served lordship at least. Due
These are
diligence
not-
was there lordship.
These are not for us to look into in the criminal revision. Huh? Can we look into all that?
Yes lordship, I have.
Respondent number 1 is not responding.
Is the state lordship.
This is the law. Huh? But should we interfere in this kind of revisions? Then I think you better not respond. But Mr. Your name, sir? Also heard Mr. M. Khan, learned counsel appearing for the respondent number 2, Mr. B. Sharma, learned APP appearing for the state. This criminal revision has been filed. Is selling. The judgment and order dated 15/6/2024 passed in criminal appeal case number 24 within bracket 1/2018. Passed by the additional session judge within bracket FTC Karimganj, Assam, dismissing the appeal and thereby affirming the judgment and order dated 21/4/2017 passed in CR case number, ये page number 1 or 2 से ले लेना, हाँ? हाँ? ठीक है? Full stop. The grounds for preferring this criminal revision petition are as follows. Page 6 से ले लेना, हाँ? Mr. Ullah, learned counsel appearing for the petitioner, has submitted that the trial courts have not appreciated the evidence of the parties in their true perspective, and therefore both the orders of the Lord trial court and the orders passed by the appellate court deserve interference in the hands of this court. Mr. The Lord counsel for the petitioner has further submitted that the assumptions drawn by the learned trial court regarding the existence of a legally enforceable right without there being any documentary proof thereof, comma, the fact that the notice remained unserved upon the petitioner, and that when two cross cases were filed in two different courts on the same subject, comma, they were required to be tried together, have been ignored by the learned trial court and the appellate court, and therefore this court should exercise the revisional jurisdiction. Full stop. Mr. M. Khan, learned counsel appearing for the respondent number 2, has submitted that the trial courts have come to a concurrent finding that there is a lawfully enforceable debt, comma, that the learned trial court and the plea of the petitioner for clubbing the two cross case had been considered and rejected, and therefore it is not a case of non-consideration. And finally, it is not in dispute that the notice had been sent to the known address of the petitioner, which is also an admitted position. And the petitioner did not fulfill the demand of the notice even when he received notices from the trial court regarding the initiation of the complaint case. Yeah, you are depending on what, sir, which judgment? The learned counsel for the petitioner has placed reliance on the judgment. Yes, what is this? In this arneculum, what do you want to show?
Lordship, first of all, Lordship, is the
Arneculum.
Lordship. PP, the Honorable Mr. Justice PP Kunhi Krishnan.
Kuni Krishna.
First, Lordship. Secondly, Lordship.
Which page? Which paragraph?
His Lordship, for Lordship, the
Has
the first paragraph.
relied upon the judgment and order dated 25th of July 2025, passed by the High Court of Kerala in criminal revision petition number 408 of 2024. I am writing one with red pencil. That any debt arising out of an illegal transaction cannot be considered as a legally enforceable debt. And
Secondly, Lordship, Suresh versus Sanjay, Lordship.
on that, in this case, only that line?
Yes, Lordship.
Okay. Then
Secondly, Lordship.
who versus who? Suresh versus Sanjay, yes.
Lordship. At page number 7, Lordship, para 15, Lordship. If two views comes, Lordship. Page number 7, Lordship, at para 15. If two views are possible on the evidence produced in the case. 1.2, the guilt of the accused and
In the case of Suresh versus Sanjay, by the order of the 30th of January 2026, the High Court of Madhya Pradesh at Jabalpur had held that when two views are possible, the benefit of doubt is to be given to the complainant. If benefit of doubt is to be given to the to the accused. Sorry, to the accused, not to the complainant, to the accused. That is the view which is more favorable to the accused should be adopted. In that case, the notice about the dishonour of the check and for payment of the amount in question was not given at the correct address. Stop. What about the third?
2010-11 SCC Lordship, 441 Lordship. At page 28 Lordship, after discussing all the facts Lordship, the court observed that Lordship, if the accused is able to raise a probable defense which creates doubts about the existence of a legally enforceable debt or liability, the prosecution can fail. Is that page 28?
In 2000, the learned counsel for the appellant had thereafter, for the petitioner has thereafter placed reliance on the judgment of Rangappa versus Sri Mohan, 2010-11 SCC 441, where at paragraph 28, the apex court had held as follows. What was your probable defense? Sir, what was your probable defense?
My defense is Lordship, the court must take the.
How did he get the check?
He lost it somewhere, he found.
Just see. It is a settled position that when an accused has to rebut the preponderance of probabilities, therefore, if the accused is able to raise a probable defense which creates doubt about existence of legally enforceable debt or liability, you must first raise that ground that there is a doubt whether I have got a legally enforceable liability or not. Is it not?
Yes, Lordship.
What ground did you raise? What is the ground? Did you take any such ground?
Lordship, I have examined myself, Lordship, DW1, Lordship.
Saying that there is no legally enforceable debt.
Yes, Lordship.
That everyone will say. You must raise a ground that this is why it is doubtful. The doubt that you created, the loss of check, has been rejected by both the courts below on facts and appreciation of evidence. Where was that ground raised?
My submission is Lordship, when Lordship, I have lost a case Lordship, then Lordship, the case must be exercised Lordship in a similar court Lordship. And Lordship, the check which was found Lordship, while Lordship, I'm first Lordship lost GD&T made Lordship.
That has been found to be doubtful. That has been found to be doubtful is the problem by two courts, not one. And one of the court has given a list that these checks which were said to be lost have been encashed by self.
When the cross-examined Lordship, I have submitted Lordship, stated Lordship, 7 checks Lordship. Out of 7
We are not on there.
2 checks were drawn by me Lordship, as per the statement of the PW2 Lordship. 2 checks only. The 5 checks remain Lordship unplaced Lordship, including the present check Lordship.
You did not take it to the office or to the bank. Maybe realizing that I'll get caught, why did I do it? But all those checks which you said were lost in 25 numbers of check, all been withdrawn by you, all in self, except one, some Chiranjeevi took it. Otherwise, everything has been drawn by you.
Who was not drawn Lordship?
Eh?
All was not drawn Lordship.
50? Page 50? Take a look.
No Lordship.
What is page 50? We are wrong.
Lordship.
Hopefully, yes, page 50. Eleven checks.
11 checks.
Not 7, 11.
11 checks out of 25, but.
And out of them?
But at the cross-examination Lordship, he stated that Lordship, 7 checks Lordship. About 7 checks Lordship.
Huh?
In his cross-examination Lordship.
He denied that he had, huh?
In his cross-examination, Lordship, he stated 7 checks.
What is this then? From where this has come? Self. In his cross-examination, he denied that on.
Out of 7 checks, Lordship, the
Yes,
PW2,
what will we see? Please, para 28, na? Where para 28 I have said, na? Where para 28 it has been held as follows. Full stop. The learned counsel for the petitioner has also placed reliance on Nathilal.
yes, Lordship. This is, Lordship, for cross cases, Lordship.
Nathilal.
Nathilal and others, versus state.
For Nathilal and others, where the apex court had held that
Judgment to be pronounced.
judgments to be pronounced with the same judge, one after the other, in the matter of cross cases. What was your cross case?
Cross case was, Lordship.
Cross case that he has stolen the checks.
Yes, Lordship.
Huh?
Yes, Lordship. Well, not stolen, Lordship.
Then?
Found, Lordship, somewhere, Lordship. Missing, missing, Lordship, I learned this.
Anyway, by in the last 14 years, you must have been able to accumulate that 6 lakhs. Hopefully. The learned counsel appearing for the respondent has placed reliance on the respondent number 2 has placed reliance on the judgment of the Supreme Court in Amit Kapoor versus Ramesh Chandar and another, reported in 2012, 9 SCC 460, where at paragraph 8, it has been held as follows, full stop.
My lord, in
Then?
HCC paragraphs are changed.
Huh?
In HCC book, Lordship, in paragraph 11 and 12 is there. But
Paragraph 11 and 12, okay.
I'm giving them.
Huh?
Same thing, paragraph 8 contents is 11 and 12.
At paragraph 11 and 12, huh? You take from SCC. Huh? You give a printout from the SCC online or give a photostat copy, huh?
Giving them.
We'll keep the book. Okay, you keep the book itself then, huh? Return it later. Then he has also placed reliance on which one?
2007, 6 HCC.
2007 6 SCC 355 CC Alavi Haji versus Pallapetti Muhammad and another. Where at paragraph?
Paragraph 14, 15, 16 and 17.
14, 15, 16 and 17. The apex court has held as under. Okay. This Basilingappa is also what you are relying upon, no?
Yes. Basaling Gapa. Yes. Paragraph 25 and 26.
The learned counsel for the respondent number 2 has also relied upon the judgment of the apex court in Basa Lingappa versus Mudi Basappa, reported in 2019 5 SCC 418, where at paragraph 25 the following has been held. Stop. Having heard the learned counsel for the parties and having gone through the materials available before this court observes that there has been a concurrent finding by the trial court and the appellate court, and this criminal revision has been filed to challenge the same. Therefore, it was incumbent upon the petitioner to have placed before this court the specific instances where there has been either a non-appreciation of evidence or a patent defect, comma, error of jurisdiction or of law, or where there was non-compliance of the provisions of law, or that there was a finding recorded based on no evidence, where material evidence had been ignored or judicial discretion was exercised arbitrarily and perversely. Full stop. By this present petition, it appears that the petitioner has tried to find fault with the manner in which the evidence has been appreciated. In such circumstances, this court is of the view that the exercise of the powers under section 482 of the CRPC, within bracket erstwhile likhi dibo, are not called for. কি কয়? CRPC নহয়. For exercise of powers under section 438 read with section 4. পানি গিলাস সঙ্গে। পানিটো 438 read with section 442 of the BNSS 2023 are not called for. Full stop. Accordingly, this criminal revision petition is dismissed. Parties are left to bear their own costs. Not necessary to write that sentence. Most time not necessary.
তো কালি ল'ব হা